Yes.
I beg to mention, my lord, for listing one petition, my lord, the pension matter, my lord, and this matter, my lord, will be settled between the parties, my lord.
Settle be
Yes, my lord, yes, in mediation.
Oh, settle mediation.
Yes, yes. Therefore, my lord, for listing.
Okay, 26.
Similar, Lordship, for listing.
When was it last listed?
Last listed, Lordship, it was in 19/8/2024.
19/8. That was just, any mediation result in that case?
No.
No. 31st then. Okay.
Lordship. May I please, Your
Yes.
Lordship, my lord, I beg to mention for listing of a read petition for orders, my lord. It's a service matter, my lord. The petitioner was a CRPF constable. He was removed from service due to misconduct, my lord. We are praying for setting aside of that order.
Readings are complete.
Not complete, my lord.
When was it last listed?
It's last listed on 19/5/2026.
They give a date.
11/7.
May I pray for listing of fresh motion matter tomorrow, Your Lordship?
What is the urgency?
Lordship, otherwise, the services of the private respondents have been regularized, Lordship, without following the due process.
Pretty regularized, isn't it?
Lordship, right.
Come up someday next week. 31st.
The Lordship, may I pray for Monday, Your Lordship, 24.
Why?
The notice needs to go, Your Lordship.
There are many matters. Monday. 31st.
Lordship.
May I please, Your Lordship?
Yes.
Lordship, I am praying for a listing for this matter. The case number is WPC number 2198 2026.
Listing for what?
Yes, Lordship. The Lordship, the opposite party has been proved forgery documents, and they have already
No, please answer my question.
orders.
Want it to be listed for orders?
Yes,
Readings are complete or what? What? Not complete.
completely.
Now, when was it last listed?
Mr. Lordship is 15/6/2026.
Okay, give a date.
May it please your Lordship, with consent to the other side, I beg to mention item number 15. We will file rejoinder for this matter, your Lordship, within 1 week.
Is there any interim order?
No, your Lordship.
What is your good name?
Eldas,
Item 15.
15.
Learned Counsel, Mr. Eldas submits for the petitioner, Mr. Eldas submits that he may be granted 1 week time to file rejoinder affidavit to the agreement possession of the respondents. Praise the Lord. Just again after 2 weeks.
Obliged.
May it please your Lordship, I beg to mention item number 24 for hearing. My senior counsel, Mr. R. Goswami, has some difficulty today. Lordship may kindly adjourn the matter for today.
Item 24.
26, Lordship.
Oh, 6. Please for respondent number 2.
Lordship.
Who is respondent number 2? Claimant.
Lordship, we are the insurance company.
Consent has been taken.
Yes, Lordship, we are for appearing respondent number 2, insurance company.
You have taken the consent.
Yes, Lordship, we have taken.
Okay. Star Goswami, Learned Counsel for respondent number 2, said to have some personification. To conduct the case today on a prayer made on his behalf and not objected by the other side. My first stand said draft. Just said again on 17/9/2026. Stop. Since the matters of the year 2016, it is expected that two parties will not seek further adjournment on the next day.
Obliged, Lordship.
May your Lordship, with the consent of the other side, I beg to mention item number 23 of daily list as my senior is out of station. Your Lordship kindly fix the matter on the first week of September.
You are for the petitioner.
Yes,
And who's your senior?
Mr. S. Vishwas.
S or M?
S.
Falsely says M Biswas.
Hmm?
Item 23, isn't it?
Yes, item number 23.
The cost list says M. Biswas. And one is S. Datta.
S. Vishwas.
Milord, I am for the respondent, Milord Bank. Now, they have their own difficulties. I have my difficulties as well, Milord, in the sense, the record hasn't come yet. So, your lordship, if can accommodate us for another 4 weeks' time. Because earlier it was under United Bank of India, that entity has now been defunct. Now, Punjab National Bank has come. Now, this record, Milord, could not be traced out yet. The record of disciplinary proceedings.
Now, if we grant you 4 weeks' time, what is the chance of getting it, tracing it out?
Let's see, my lord,
Do you have a better chance you take more time?
yes, I'm thinking so, my lord. I had a talk with the
See-
chairman. My lord, he assured that he will try his best.
You try, but that trial can be done within 2 weeks also. The reason is, see, the
I
matters,
understand, my lord. It's a
matters of
pretty old-
2014, that's why it doesn't look good.
Yes,
The matter pending like that for a long time. We'll grant you,
that's true, my lord.
we'll have it in the first week of September.
Sir, can it be second week? My lord? First week, I may not be available.
Okay. A prayer for adjournment has been made on behalf of Mr. S. Biswas, who is said to be the conducting counsel for the petitioner. To the effect that as he has some personal difficulties to appear in the matter today, matter may be adjourned. Stop. Mr. S. Datta, senior counsel, appearing for the respondent bank, suppose that he has no objection to the prayer. And in fact, he prays you and further prays for 4 weeks' time to enable him for 4 weeks' time to produce the records. Stop considering the fact that the matters of the year 2014, that the matter be listed on a hearing date, 10 September, please.
God bless you.
Well, it was actually mentioned item number 18 to 21. In item number 18, the respondent has filed their counter yesterday evening. So I only pray that Allah will grant me 10 days time to reply.
You're for the petitioner.
Yes, I'm for a petition. Pursuant to a lordship's order, they have filed a counter, but they filed it yesterday evening. I need 10 days time to file my response.
Mr. J. Patwari, learned counsel for the petitioner, submits that he has just received a copy of the affidavit of possession filed as a respondent. And therefore, he prays that he may be granted 10 days time, go through the same and file a rejoinder affidavit. So, prayers aloud.
My lord, there are interim orders operating in the petition, which may be continued.
List again on, give it. 31-10, 31-8-2026. Interim order passed earlier.
To continue.
In which case?
In the writ petition.
In all the writ petitions.
No, in item number 20 and 21.
In WPC number 4108 of 2025 and WPC number 2759 of 2026 shall continue till the next date.
WPC 1038 and 4108, there are interim orders.
You said 20 and 21.
I have like that, I am sorry.
Oh, so you correct that, okay?
Yes.
2759, that cancel that. Instead, you write 1084 of 2025. And the other one is 410.
410.
Yes.
May please, your lordship. With the consent of other side, lordship, I beg to mention item number 1. Here, lordship, I am supposed to place the instruction, lordship, due to some inadequate instructions have been received, part instruction. Let it be fixed on 4th September. I have taken the consent of the petitioner, lordship. Yesterday, I have taken the consent, lordship.
4th September.
4th September, lordship.
4th is already.
Sorry, 7th.
Okay. Mr.
SS Roy.
S.S. Roy, learned CGC, submits that he is yet to receive instructions in the matter and therefore raise that further 10 days time have been granted to him to receive instructions. He submits that he has also taken the consent of the other side. This is the matter on 7th of September 2026. Yes.
May it please your lordship. My lord, I beg to mention item number 5, lordships. Lordship, in this, I am the petitioner. I have to submit a detailed affidavit, lordships, and according to the order dated 21/7/26, lordships. It is being prepared, lordships. The petitioner presently, he is bedridden. He is a cardiologist, but still he is bedridden. Lordships, at least 1 month time may please be given for filing the detailed affidavit.
Detailed affidavit regarding
That issuance of show cause notice, reply of show cause notice, then enquiry, thereafter lordships, in details I have to submit.
okay,
And accordingly, an order was passed on 21/7/26,
okay, you are Mr. Sharma.
lordships.
Mr. R. Sharma, learned counsel for the petitioner. Since the petitioner is not in the best of his health, prays that he may be granted 4 weeks' time to file the detailed affidavit in terms of the last court's order. Considering the affair, that best stands to John for about list again on service.
May please your lordship. Lord, I beg to mention for listing a pension case of 2024. May be taken up it on my lord next week.
When was it last listed?
My lord, the order matters, my lord.
When was it
The
last?
last listed on my lord 15/6/2026.
We have a date, September. 9 September.
Highly obliged.
May it please your lordship. Lordship, I beg to mention for listing of a matter, my lord. It was last posted on 18/5/26, my lord.
For admission?
Yes.
Okay.
May I please it?
Obliged.
Lordship, I beg to mention for listing lordship, new case lordship, I have filed matter relating to pensionary benefit laws. First of others, I have filed lordship.
Give a date.
Okay.
Wait, please, my lord. I beg to mention item 29, my lord. With due consent from the other side, I humbly pray that the matter may be adjourned, my lord. On the ground that the conducting counsel, Mr. Fukun, has some difficulty today, my lord.
PJ Pugan.
Mr. P.J. Fukun.
Okay, therefore adjournment has been made on behalf of Mr. PJ Pugan, learned counsel for the petitioner on the ground that some person who had appear before the court today. We will sit again on the phones. Okay.
May I please? Lordship, the petitioner herein is working with the Bank of India who are the respondents. She is a staff officer grade 2 in Tezpur branch, and she has been posted in the state branch in the in the month of on 25/8/2025 from Srinagar. I take your lordship to the documents directly without the husband of the petitioner.
Where is she posted?
She is posted in Tezpur branch.
Tezpur branch.
Yes, Tezpur branch.
This is a bank. What is this? Bank of India.
Bank of India.
Yes, yes.
The husband of the petitioner, he is suffering from 75% permanent locomotive disability, which is at page number 42, annexure 1. The disability certificate I have annexed. The husband of the petition,
Yes.
the husband of the petitioner is an assistant executive engineer mechanical. He is working with the Border Roads Organization under Ministry of Defense. He is also posted in Tezpur. So they both are posted in Tezpur and their posting was from Srinagar to Tezpur on the basis of a spouse posting.
The wife or the husband
The wife's posting
from Srinagar.
from Srinagar because they both were posted in Srinagar. From there, they have requested that they need to be posted together because the husband's posting came before. So I'll take your lordship.
Both of them were in Srinagar.
Both of them.
The husband was then posted to Tezpur.
Tezpur.
Then the wife also requested.
Yes.
She also has been posted
Posted
in
to
Tezpur.
Tezpur. Yes.
Now she's been posted out from Tezpur. That is why you're here.
Yes.
Where is that
Not
order?
Tezpur. I'll take your lordship to annexure number 2, page 43. This is the posting order of the husband.
To Tezpur.
Yes, to Tezpur. On 25th July 2025.
That is not in dispute. Now
Yes,
you're
that is not
disputing.
in
Now
dispute.
your claim is,
Then-
your grievance is
Huh.
regarding your posting.
Posting. Thereafter, the wife has submitted a representation, which is annexure number 3, page 45. That she need to be posted to Tezpur and it was done accordingly. There was also a recommendation from the commanding officer of the husband. May I just read that portion? Which is at annexure number 47. Annexure,
Page number 47.
page number 47, annexure
Annexure
4.
number.
4. May I read?
Yes.
It is certified that GOE so and so, rank so and so, RE so and so is serving as General Reserve Force Engineering Border under Ministry of Defense, Government of India since 5 November 2020. The officer has been appointed against the vacancy post with disability. He is presently posted in so and so, Jammu, Srinagar, Jammu and Kashmir. Now, as per posting order so and so, border white so and so, dated the EBW, which is located in Tezpur. The spouse of the officer, Sonia, who is a petitioner, is working as a manager in Bank of India government undertaking at Srinagar branch of BOI. Considering the fact that physical condition of the officer is with 70% disability and he needs constant family assistance in his daily routine. Further, Kashmir is extreme hostile insurgency and will become very challenging for the lady to manage her service along with her husband is posted out. This is location, hence the interest of both the organization. That Miss Sonia Uttam Rao Gaikwad, wife of so and so, is transferred to any location closer to her spouse. So this was a recommendation by the commanding officer also. So accordingly, Lordship, she was posted to Gauhati zone and thereafter to Tezpur, which is at annexure number 6.
Just a minute. This recommendation has come from the
Husband. It was recommended
by the CO
yes of the husband because
of the husband.
because he is 70% disabled. So that was
Recommendation is given to whom? To the bank.
to the bank. It was given to her. She has submitted to the bank along with her representation. So thereafter, she was
So the officer commanding the husband's posting has
Yes.
given recommendation to the employer of the wife.
he have written it to the he have given it to the wife. The wife have submitted along with her representation that they both may be posted to Tezpur. To whom it may concern. It starts with to whom it may concern.
Prior to this letter,
Yes, Lord.
husband was already posted in Tezpur.
Yes.
So the
That's
OC
what-
has given a recommendation.
Recommendation.
And on the basis of that, she has been transferred.
Transferred to Tezpur, annexure 6, page number 52. 17 September 2025.
Yes, then
So initial period, they were staying outside since there was no quarter vacant. On 20 May 2026, the husband was allotted a quarter and they both have been staying in the quarter, which is at annexure number 7, page 53. Now, Lordship, page number 54. The wife was again transferred from present posting, which is at Tezpur, to Charidwar branch. Annexure 8. Your lordship can see page number 54. Not even a year. It's only 8 months, around 10 months of posting. She was transferred from Tezpur to Charidwar branch. And she was on, this letter is dated 6 August 2026. And thereafter, on 8 August, she was relieved. On 10th August, she was relieved within the period of 4 days. So the husband of the petitioner submitted a request letter, which is at annexure number 10, dated 7th August 2026, requesting the zonal manager of the branch for review and cancellation of transfer order of his wife. He has specifically stated in his representation that he has a benchmark disability. His wife is serving as an administrative manager in the bank. Earlier, where they both were posted and transferred to Tezpur, my wife applied for transfer in spouse posting considering my benchmark disability. However, without informing my wife, the zonal office issued a transfer order to Charidwar branch. Suddenly, the transfer has caused immense hardship and serious practical difficulties. Due to my 70% benchmark disability, I depend upon my wife for my daily support, mobility assistance. My government accommodation is situated just in front of the bank, Tezpur, and her transfer branch is around 30-35 kilometers away, has created serious hardship and adversely affected my day-to-day life. I therefore humbly request your good office to kindly review and cancel the transfer order. So this is the transfer request which was made. Thereafter, lordship, the wife also submitted a detailed representation, which is at annexure number 11, page 59. Via email, she have written it to the bank HR. In that email, she specifically requests that, may I read lordship, page 59, annexure 11.
Where has she been transferred?
Charidwar.
How far is that from Tezpur?
It is around 30 to 35 kilometers as stated. 30 to 35 kilometers. Like 25 to 30 kilometers. May I read also?
Read what?
The annexure 11. Her representation. Yes. Respected sir, I so and so staff officer working zonal branch presently stand transferred from Tezpur branch to Charidwar branch. In view, I need to request my representation to be considered on facts. My transfer to Tezpur was on a request on the ground based on spouse posting, depending with the disability of my spouse working in defense, serving with BRO so and so so and so. Accordingly, as per the HO transfer order, so 26 August 2025, I was transferred to Tezpur branch, Gauhati zone from Srinagar of Amritsar zone. I have completed a very short tenure of 10 months on Tezpur branch, whereas an officer can be posted up to 3 years in the same branch as per the bank policy and RBI guidelines. My husband has been allotted government accommodation at Tezpur, which is situated close to Tezpur branch. The present posting enables me to discharge my official duty while also remaining available and care of my disabled husband. The proposed posting at Charidwar branch is approximately 25 to 30 kilometers away from the present resident located. That would involve daily travel of around 50 to 60 kilometers and 2 to 3 hours of commuting. That will impose additional burden of traveling distance, prolonged sitting, financial expenses, causing immense consideration of physical, mental, and financial hardship. I have been suffering from severe spinal issues, of which I have undergone prolonged medical treatment in last 2 to 3 years. Please verify through HRMS record for EOL taken for treatments. That is the internal records which they submit. Presently, on 10th, I underwent surgical procedure for Dyson on inner side of the mouth. Now I am under post of observative care. This administrative transfer causes financial loss to the bank, as well as relocation will create need for another accommodation, additional expenditure. The bank need to resume various financial facility like subsidized accommodation, joint leave, altering, traveling, transportation expenses. In view of my husband's benchmark disability, my responsibility as sole caregiver, my medical condition, hardship involved these facts. All the facts have been brought to the notice of the zonal authorities during the personal visit. My transfer is biased decision made over misleading information providing by the present branch manager of Tezpur. This is an injustice to me, so and so, so and so. So this is the representation given to the zonal office, zonal manager. Annexure 12, page number 63, her medical conditions. She's been suffering from cervical spondylitis and all. So these are the medical documents which I have also annexed with the in the present petition. Now, Lordship, I'll take your Lordship with page number 69. What is the transfer and posting policy of the bank? Annexure 13. We start in page number 69.
Show me the relevant portion.
Yes, Lordship. Basic principles, clause 2, Lordship, page number 70.
Yes, read.
Yes. As the general rules, as far as possible, annual transfer policy officer, including administrator, should be planned in advance and transfer order shall be released on or before 30th April. So the transfer should be planned in advance, the first. The relevant is 2.2. Except on emergent circumstance, an officer should be given minimum 15 days notice, which was not given to me, in respect of his or her transfer from one station to another, so that he or she can make adequate preparation for winding up of his or her establishment and shifting of new station. As per CVC RBI rotational policy, no officer shall be retained in the same post desk for a period of excess of 3 years. So I have just been posted. My tenure was 10 months. 3 years in the same branch, an officer department central for a period of excess 5 years unless otherwise warranted. Now, clause 4, posting of officer who have differently able dependents, which is in my case. The para 3 of the guidelines should also apply to all purposes and intent to officer who are caregiver of differently able dependent daughter, son, parent, spouse, brother, sister with specified disability, as certified by the authorities of benchmark disability as defined under section 2R of right to person with disability. May be exempted from routine exercise of transfer, rotational transfer, subject to the administrative constraint provided such disabled person is staying with the officer. In my case, we are the only 2 person in the family. Like my husband is totally dependent upon me, as Lordship can see from the representation. The transfer of female officer, clause 5. Placement and transfer of female officer will be done given due importance to safety and availability on the basis of amenities. As far as possible, her request for transfer placement may be done in a place where her husband is stationed or nearer as near as possible to the place, or vice versa, or at place where her husband are stationed or near the as possible to the place the transfer will be done. On the best effort basis of the bank reserve the right to reject the request, if any, and any female officer if business and administrative imperative justifies. In my case, the only ground which has been given is it is an administrative transfer, nothing else. Business and administrative imperative would include the need for the bank to impart skill set required to ensure that the officer is capable of assuming higher responsibility, or need the bank to ensure completion of rural or semi-rural urban exposure. Safety of female officer would be given due importance, and availability of basic amenities would be given. Then yes. Then I'll take your Lordship to page number 75, clause 7. Relevant is 7.11. In addition to the available grounds of transfer, the ground of marriage, spouse, medical, maternal, child care, far away posting also be considered. In case of spouse working in central government, and endeavor to post them in the same place, region, or nearby place, region will be ensured. So as per their own policy,
So where are you now?
So now I am presently in Tezpur branch. They have released you. They have released me from within a period of 6 days, but at least a time period of 15 days need to be given. as per their own guidelines. So I'll take your lordship to the office.
So where are you now? You have to join the new place.
No, I have not joined lordship. I am
Why?
on sick leave. I have stated lordship.
You're on sick leave.
Yes, I am on sick leave.
Where is your leave? For how many days?
Lordship on medical leave, lordship. She have underwent some surgery. So
No, how many days leave?
I think 2-3
For
days.
whatever
are left,
reason.
lordship.
Huh?
2-3 more days are left, I guess.
2-3 days more.
Yes.
Tell us, be specific. When did you take leave?
Lordship, on medical grounds stated in my
When did
representation.
you take leave and for how many days? Was it granted?
Lordship, I have to take instruction on that aspect.
Then why did you file this writ petition without knowing anything?
Lordship, because I have been transferred this application. I have in my representation itself, I have stated that I am suffering from and I have undergone medical treatment at presently on 10/8/26. I under 10/8/26, Lordship.
Don't go back to the same old facts again. You see, I'm asking you a specific question.
Let's see, Lordship, is
When
there.
did you take leave? When,
Ten-
when,
10/8/20
how many days?
10/8/26, I went a surgical procedure for excursion 10/8/26, Lordship.
That is your surgery.
Yes.
I'm talking about leave.
Lordship, thereafter I have not joined, Lordship. After 10.
Thereafter, when? Thereafter?
10/8/26.
Where is that 10/8/26?
Lordship, page 59. Point number 5.
Point number 5.
5, Lordship. Presently on 10/8/26, I underwent a surgical procedure for excision of.
Page number?
Page number 59.
59. Point number 5.
5 below, Lordship. Second paragraph of point number 5.
Okay, second paragraph.
Yes.
Presently, surgical procedure for excision of lesion on inner side of mouth, and now I am under
Post-operative care and has been advised 7 to 10 days of.
rest by doctor.
Yes. I'll take a lordship to the office memorandum.
No. Your leave was started from which date? Your posting order is of 6th August.
6th August, Lordship.
Then you were relieved on 10th.
Lordship.
Is that what you said?
Yes, 10th, Lordship.
Is there any release order?
Lordship, this is the only email which she got, Lordship.
I think an extra 9 is the release
Yes.
order.
Yes, Lordship.
And on that day itself, you went for that mouth surgery.
Yes, Lordship.
Hmm?
Yes.
Then where is your leave? Paragraph 5 is only advised to take leave for 7 to 10 days.
Lordship.
But where is your leave?
Lordship, at present, I'm on leave, Lordship, but if required, I'll place it on additional if requested or not.
So that's your case.
Lordship,
What more?
Lordship,
That is all, I think. Anything more to add?
Lordship, the office memorandum.
You come down from Srinagar, both husband and wife, you were
Yes.
posted in Tezpur.
Yes, Lordship.
First of all, you were staying in some private accommodation.
Yes, Lordship.
Later on, quarter was given to you.
Yes, Lordship.
While you were in quarter, now suddenly you have been transferred out.
Yes.
And as per the transfer policy, you should be given 15 days time.
Yes.
And stationing should not exceed 3 years. You've hardly been 1 year also.
Yes, Lordship.
These are all your cases and
Yes.
70% disability.
Disabled husband. And as per the office memorandum, also Government of India.
See, end of the day, transfer and posting matters, you know very well the limitations
I understand, Lordship.
for a court to see into these aspects because it's the employer who decides what is the right thing. Of course, they will have to decide judiciously also as
Yes.
per their guidelines as well
Yes, Lordship.
and taking into account all these factors.
Yes, Lordship.
Now you have, I think, 1 or 2 representations pending. Let this be considered. What more can we say now?
Lordship,
If I may just point out one thing.
the
You're on caveat.
Yes, I'm on caveat because the petitioner went to the bank and threatened to file a court case.
no, that is not the.
Let me, I do not
I have
interrupt
not
my learned
completed,
friend,
Lordship.
Malad. So
I have-
we have anticipated this case, Malad. Oh, now what has happened, Malad, the distance between Tezpur and Charidwar, I belong to Tezpur Malad, personally. The place where she is staying, Vartak Vihar, and up to the Charidwar, the bank, it's not more than 25 kilometers, roughly from here to Borjar Airport. Malad. Now, Malad, admittedly, Malad, the bank has entertained her every request from Srinagar to Gauhati to Tezpur. And even Malad, she was posted that the branch is just
just near that Vartak where she is residing. Now, it is not a case, Manoj, where the husband is so disabled that he is a bedridden person. He is himself in service. And this is nothing but her ego. Moreover, she has filed a representation as per the transfer policy. He has stated in para 18 of the petition that I have filed.
That's what I'm saying. You see, to cut the matter short,
Lordship.
and you consider the representation
Lordship will have-
properly in terms of your guidelines.
Lordship will have page 82 minutes. This is the transfer policy, Manoj. And in fact, Manoj, in a sense, the petition is premature. Because if your Lordship has page 82, the clause 17.7 and 17.8. But grievances received from employees citing violation of transfer policies will be dealt with considerate manner as per the grievance redressal policy of the bank amended from time to time. Next, with respect to written appeals received from transfers from the employees, committee is consisting of following members who look into the issue and dispose the appeals within 15 working days from the receipt of appeal. And the representation she has given on 12th of August month, and today is 18 now. So even 15 days have not transpired. The lordships are aware, in SC Saxena's case, Supreme Court has said you first join, then you file representation and agitate your grievance. So not in that view of the matter, and transfer orders, lordships have also held in a number of judgments, that transfer orders need not be speaking orders per se. We are only required to satisfy the court. That's a subsequent thing. So
See, we are not saying anything on merit. What I'm suggesting is that perhaps you consider this representation submitted both by husband and wife in terms of your policy and take a decision.
Yes. Well, she has submitted on 12/8. We will take a decision by 27/8, 15 days. That is the time under the policy. Today it's 18. But you can dispose it off on that basis.
Yes, Mr. Counsel.
Yes, till that date, let her be in that branch itself.
So she has been relieved, madam.
You've been relieved. You're on leave.
And she has 48 days sick leave, so she can avail that.
Lordship will also take into consideration the office memorandum issued by Government of India.
No, that would have been a case. She would have definitely had a case had it been a case of interzonal transfer. Here she has been transferred, my lord, from here to there, just a stone's throw. It takes half an hour to 40 minutes, my lord, and even then she's not ready to go. It cannot be a matter of ego, my lord, or of vanity. She cannot insist that every place, my lord, I'll have a bank branch like this.
Great.
May I take your lordship to the office memorandum of Government of India?
So why do you want me to adjudicate the office memorandum? Let the bank consider this aspect as per the office memorandum.
Lordship,
they are aware of their office memorandum.
It is otherwise binding on us, but that is, my lord, in case of the interzonal transfers.
Lordship, till then, at least I may be protected, Lordship, till they decide the representation.
She is already, my lord,
because
relieved. How
Lordship,
can she-
see, they,
clock can be turned
as per
back?
their own policy, they cannot relieve a person within 15 days. How they have done it? If the rule applies to me, then it applies equally to them also.
Well, Lordship,
Their relieving order is also bad in.
we will decide, my lord, in terms of the transfer policy.
Yes.
That's the only thing.
Heard, Mr.
F.R.E.D. Lordship.
F.R.E.D. Learned counsel for the petition. And Mr. A. Ganguly. Learned. You're a standing counsel.
No, ma'am.
Learned counsel for the respondent bank on caveat. Stop having regard to the grievance projected in this petition. The same is taken up for disposal at this stage. Next, matter. It is the case of a petitioner that she is serving as a staff officer, Roman 2, under the respondent bank, and was posted to the Tejpur branch of the bank from Srinagar on 25/8/2025. Stop. The petitioner's husband is also working as the assistant executive engineer under the Border Roads Organization and posted in Tejpur. Stop. The petitioner's husband is 75%, I'm sorry, 70% permanent locomotor disabled. And therefore, it was on this ground that the petitioner secured her transfer to Tejpur, where her husband is posted. Apart from the fact that such common posting is permissible if both the husband and wife are in service. Of the petitioner and her husband initially were staying in their own accommodation in Tejpur and subsequently were allotted a quarter. Stop. However, to the surprise of the petitioner, she was transferred to Charidwar and the same was communicated to her wife. Communication dated 6/8/2026. Stop. Consequent upon the transfer order, the petitioner was also released. Not released, you write relieved from our posting in Tejpur to join the new place of posting. Write communication dated 10/8/2026. Stop. Agreed with the same. The petitioner, the petitioner's husband submitted a representation to the zonal manager, Bank of India, Gauhati zonal office, on 7/8/2026. Which was followed by a representation submitted by the petitioner herself to the same authority on 12/8/2026, requesting for review and cancellation of her transfer order. Despite the same, since no steps have been taken by the respondent authority to consider the representation, the petition is before this court. Next, para the learned counsel for the petitioner submits that. The husband of the petitioner is 70% permanent locomotor disabled and requires assistance from the family members constantly. So apart from the petitioner, there are no other family members living with her husband. And therefore, she is required to assist her husband by staying by his side. Stop. The learned counsel further submits that as per the transfer policy followed by the bank, except in emergent circumstances, an officer is to be given a minimum 15 days notice in respect of his public hard transfer from one station to another, so that there is enough time to make adequate preparation for winding up and shifting to the new station. Stop further. Ordinarily transfer to a particular station should not exceed 3 years. Which can be extended to 5 years, depending on the circumstances. Stop. As for the petitioner, she has not even completed 1 year in the station in the Tezpur branch, and therefore the transfer order has come at a premature stage. Stop. The learned counsel submits that there is also a provision which provides that officers who are caregiver of differently able dependents, including spouse, are to be exempted from routine exercise of transfer or rotational transfer, subject to administrative constraints. Or such transfer has to be done where the husband is stationed or as near as possible to that place. Stop this apart. The safety of female officers is also given paramount importance while considering transfer. Stop. The learned counsel therefore submits that the respondent bank has, in fact, issued the transfer order without taking into account the various provisions in the transfer policy. Stop. The petitioner has been transferred to a location which is 25 to 30 kilometers away from Tezpur, and which is bound to cause undue hardship, considering the fact that the petitioner has also undergone treatment. for chronic cervical pain. No, for cervical spondylitis and acute low back pain. Stop. In view of the chronic cervical pain, the petitioner has been advised to restrict movement and avoid prolonged sitting, standing, travel, and physical exertion. Stop. Therefore, her traveling from Tezpur to the place of posting, which is at a distance of 25 to 30 kilometers, would not be advisable. The Learned Counsel further submits that the petitioner on 10/8/2026 underwent surgical procedure for excision of a lesion on inner side of her mouth and currently under post-operative care. Stop. She has been advised to take 7 to 10 days rest by the doctor. Please refer to page 59. Okay. 59. The Learned Counsel thus submits that the impugn transfer order should be interfered with by this court, having regard to the condition of the petitioner and her husband, and as well as the transfer guidelines followed by the bank. Next para pro contra, Mr. A. Ganguly, Learned Counsel, submits that the place to which the petition has been transferred is hardly 25 kilometers away, and therefore it is very much in close proximity of where the husband of the petitioner is posted. Stop. He submits that the writ petition, in fact, is premature in view of the fact that the petitioner and her husband had submitted representation. And according to the bank policy, such representation is to be considered by the constituted committee within 15 days from the date of receipt of the appeal of the representation having been submitted on 12th of August. The 15 days time has not lapsed, and hence the writ petition is premature. That's all. Next paragraph, on considering the submission made by the Learned Counsels for the rival parties. This court is of the considered view that since the representation filed by the petitioner and husband is pending consideration, so instead of keeping the writ petition pending before this court, it would be appropriate to dispose of the writ petition by directing the respondent bank authorities to consider and dispose of the representation. Stop. Accordingly, the writ petition is disposed of by directing the respondent bank, or particularly the zonal manager.
It will be the committee, man. Zonal manager will be a member.
Okay.
Committee.
Respondent bank to consider and dispose of the representation filed by the petitioner and her husband
But the husband's representation, if your lordship's direct, we will have to, but.
Okay, not required. Representation of the petitioner filed on 12/8/2026. By taking into account the grievances projected and at the same time, the fact that the husband of the petitioner is 70% locomotive disabled. And also the policy of the bank. And also the transfer policy of the bank. Such consideration should be done within a period of.
But within the lordship will indicate 27/8, that is 15 days from the date of submission. As per the proposal.
15 days from the date of the receipt of the representation, that is 12/8/2026. So in other words, the representation should be considered and disposed of by way of a reasoned and speaking order by it'll expire on 27th.
27.
By 27th of August 2026. Stop needless to say that the decision to be taken should be invariably communicated to the petitioner. Till such decision is taken by the respondent bank, no coercive steps should be taken against the petitioner.
The
Caveat stands discharged.
Must.
Yes,
Actual matter may be sent for mediation.
all right. Parties are represented by the respective councils and they submit that matter may be sent for mediation. Accordingly, registry to send the matter for mediation. All right.
Yes, mediation will not serve any purpose. The department has already filed an affidavit.
What is the matter?
It's regarding to the payment of certain salaries. We were under 3 appointees. That was
Yeah.
continued for some time, for many years in fact. And suddenly it was terminated, stopped. We continued in the meantime for a period because this order of not to extend came much later. So we continued for some months and our services were extracted. So we are claiming salaries for that. And the department has taken a stand that there is no order for keeping us appointed. So therefore they cannot pay the salaries. But our case is that there are orders to show that our duties were taken by the concerned district officers. And we have given those duty charts also. And in the meanwhile, of course, there was another prayer that has only been granted because regularization already taken place. They were also asking for regularization a process which was on hold. So that has been completed and it's finished.
Mr. Bora, what do you say?
My lord, we have filed our affidavit, my lord.
No, whether we should refer it for mediation. He says that may not be appropriate to send.
Yes, my lord.
Considering the subject matter.
The issue is that they are now claiming their arrear salaries for a period, my lord. Because we are saying in our affidavit that, my lord, that period is not, they have not been, because their term of service, my lord, that has not been duly extended because they were 3 employees, my lord. And therefore, my lord, since they do not have any valid appointment during that period, so we cannot pay the salary. So if it is referred to mediation, if something can be done, then.
Unless they budge, they say that we'll pay you some. What is the point of mediation? Because they are saying in their affidavit, we are not entitled to sell.
In mediation, if the officers come and if they say something, then it may be helpful, my lord.
Why don't you try what is there?
It's only, my lord.
Even before the matter is sent, you are saying that it may not be possible.
Because, my lord,
Because in our affidavit, our stand is that, my lord, they did not have any valid appointment during that period, so we are not going to pay their salary, my lord.
so they've expressed their mind basically, my lord, saying that now it's for your lordship to decide whether my lord will be entitled to those salaries, my lord.
In media,
No, that is what they have seen in the affidavit.
On quantum merit, my lord.
But
That's,
in mediation, well, there may be other things also.
Yes,
Which
my
may
lord.
say, give it a try.
it's only prolong the things, my lord. My lord, our experience.
No, it's not it's a case of 2025. It's not that it's been pending for ages.
And otherwise, my lord, now they have been regularly appointed and now they are getting their regular pay scale.
But that's another part of it.
Make an attempt.
That's. Live with your lordship, but then.
Parties are represented by the respective councils and they submit that the matter may be sent for mediation. Accordingly, registry to send the matter for mediation.
Oblige.
Yes, what is the subject?
Your Honor, my
Salary.
party has said he would go for the mediation.
Okay, good. Same order.
May it please your lordship. Lordship, we have been, as per the last order, my lord, this matter was heard at length by the coordinate bench of Honorable Justice Mr. UK Nair. So, my lord,
Lordship, so we have filed an IA, and the matter relates to this IA. In the last thing, we have been asked to give copies of the agenda points, which we have got. Lordship, this IA relates to a show cause notice, Lordship, issued to a probationary group A employee of AIMS who had made unsubstantiated claims and allegations against the institute and the superior officers. So what we have done is, without this thing, what we have asked in the show cause notice to furnish a reply, just a reply, which is purely an administrative matter. I'll draw your attention to para 4 at page 121.
No, you're talking about the IA. You are appearing for?
I'm appearing for respondents number 2345.
Who are they? 2, 3, 4, 5.
AIMS, Lordship. AIMS and various. Now, if we go to the main petition, Lordship, I'll page 121. Page 121, annexure 22.
In the main petition.
Main petition.
Just a minute, Sir Counsel. Respond number 6 in the writ petition. Who's respond number 6?
That is ICMR.
So there's a notice.
There is a notice.
Notice was issued and it was delivered on respondent number 6. So basically that is why it has been listed today.
for orders now.
For orders. And your IA is for what?
IA is for vacating the stay.
Vacating the stay. Okay. What kind of stay was given?
No coercive action to be taken.
My lord, may I
What has happened? Lordship, I'll give you a copy.
Any objection filed to the?
Yes, my lord, we have filed our objection. In fact,
so the entire matter was heard earlier.
yes, my lord.
Not the entire, we had started off the matter. It is not been heard.
No, what I meant to say was that leaving the IA,
Yes.
the writ petition was heard.
It was heard. It was heard. But
So there would
no,
have been.
it was heard in our absence. No.
No, my lord. My lord, may say, may check 22/7/2026.
May I complete, Lordship? Initially, the stay was obtained in our absence. We have filed an IA. We have filed an IA against this stay. And the stay is that in this show cause notice, Lordship, if I may draw your attention to page 121.
No, we listed for admission or something like that. Today, I think it's only for regularizing the respondent number 6.
Watch it. But this stay is creating administrative chaos in this thing. And it is simply an explanation. I'll just read out. You are hereby directed to furnish a specific, detailed and evidence-based reply. We are just asking for a reply that you have made some allegation. Give us a reply. So that.
But what is the hurry? What is the hurry?
Lordship, she, in the last 1 week, after obtaining this stay, she has gone on social media with comments against the Prime Minister and so many others. She has gone to social media. She is not attending regularly. She has become a tiger. We are asking simply for that you give us an explanation. There is no coercive action. It is purely an administrative matter.
So what is to be done?
Lordship, we may be permitted to ask for an explanation from her.
My lord.
You have given some allegations.
No, the other aspect which has been informed to the court is that it was heard by a coordinate bench.
Lordship.
Should it go to the same bench?
Yes, my lord, may I even, if my lord take up the matter, I got no objection. But my lord, the entire projection that my learned friend is doing is absolutely in a wrong premise. We are challenging the authority under which he has issued the show cause notice. My lord, I being a professor of a department, I had complained against him to the higher authority. And then he show causes me that how can you complain against me to the higher authority? And in fact, he has issued me warning letters for giving a reply against the warning letter. That is why this matter was heard, and that is why the court was of the view that no coercive action should be taken, and that is why the order was passed.
May I, Lordship?
Then why was it not completed?
May I,
on-
Lordship?
My lord,
He is referring to a case which has 23 writ petition 2316, which was disposed of by a court.
No, my lord.
bench of-
My lord, there is a mix.
When I
No,
didn't
no,
interrupt.
no,
when I
no,
was saying.
no.
I didn't interrupt. When I spoke.
It's my.
It was, you can be laughing. It was a writ petition 2316 was there, which had been disposed of in last year, Lordship. So this has no meaning with this. We are simply asking that she has made certain
Petitions filed by the same petitioner.
same filed by the same.
Or what was the?
No, my lord. Absolutely again misplaced, my lord, facts. I'll just come to you. My
Just
lord,
a minute, just a minute. I'm asking the counsel.
Lordship, this was filed by the same petitioner. And
What is the relief claim?
the court said that the decision is to be reverted back to the governing body, which is the disciplinary authority. So the matter was sent back to the governing body. The governing body took a decision. So that
decision is challenged here.
No, that decision is not challenged.
Okay, then.
That is not challenged. That is, in fact, that is of us, not of the same petitioner, it is of a different petitioner. So he is confused two things. That petitioner was another professor. We are talking of a different petitioner, which is in this. So that is entirely a separate matter with different petitioners.
my lord, may I just submit here? My lord, perhaps my learned friend here has mistaken the facts and submitted. My lord, page annexure 19 to the Union Secretary Health, and his representation is against the respondent number 5. By name, I have named him. And my show cause notice is also against that, and it is issued by respondent number 5. What kind of submission is this, my lord? Even without going through his facts of this case, he's submitting something which is not even absolutely absurd.
No. You cannot make personal.
I'm not making.
No.
See, that's it. See, one thing we can do. We post it for consideration some other day. Today, we take on into account the notice served to the respondent number 6. ICR.
ICMR, my lord.
ICMR, what is their role here?
My lord, what had happened, there's a project which is controlled by the ICMR, and I am the project coordinator of it. The ED does not have any role in it, but still the ED is not allowing me to function over it. And as such, is not releasing the fund. What happens is, my lord, Indian Council of Medical Research gives us a project, like this project is on tuberculosis. And then I, being a community medicine doctor, I have to take it to the entire areas and everything. So this fund has to be released by the ED. He does not releases the fund. And as such, I have made ICMR a party. My representation to the Union of Secretary on that count against the ED, my lord may see on page 115.
What is ED?
Executive Director.
Okay, of AIMS.
Yes, on the same day while online project meeting was going on, I received repeated calls from the office of the Executive Director directing me to immediately appear him before approximately 3 p.m., 3:30 p.m. After the online meeting concluded around 2 p.m., I preferred to the designated conference hall where several faculty members, administrative and project were present. As principal investigator, I am directly responsible for reviewing the performance and conduct of project staff. However, my authority and decision as PI have repeatedly been undermined, which is detrimental to project functioning and administrative coordination. The circumstances and atmosphere of humiliation and intimidation owing to the emotional distress caused by the earlier incident and subsequent public confrontation, I was unable to effectively deliver the official project presentation scheduled for the day. There, after hostile meeting with senior officers, I have named him as a person in my representation that against this. My lord, this is, my lord, I'm putting into this on record. This is a modus operandi of the ED. He harasses every women faculty that is there.
Okay.
Similarly, it has been done.
This is something which is absolutely personal,
Okay,
which is
at this-
absolutely false.
Just a minute.
I might.
But the court has given an order.
No, just a minute. At this stage, see, let us not go in all to all that. We're not hearing the matter as of now. Like I said, we'll say the notice is complete, then we fix a date.
Yes,
If
my
you
lord.
if parties agree, we can take up the entire matter for hearing.
Yes, my
You
lord.
know,
Lordship.
pleadings are exchanged already.
Yes, it's been exchanged.
Is any other writ petition connected to this?
No, my lord.
The IA is there.
Not the IE, writ petition.
No.
And any other writ petition pending?
No, no writ petition.
I is basically for modification of the interim order.
Not a removal.
So why not take the entire thing for consideration
Lordship.
instead of going for peaceful?
Take it up. Lordship.
Please write, office note dated 25/6/2026 indicates that neither AD card nor unserved notice has returned back from respondent number 6. Stop. However, upon tracking the postal consignment, it has been ascertained that the item has been delivered to the addressee. Accordingly, notice is accepted to be complete upon respondent number 6. Since no one appears for respondent number 6, court is of the view that some time may be court is of the view that the matter some time may be given for appearance of respondent number 6. Stop. It is further submitted by the learned counsels appearing for the rival parties, accepting respondent number 6, that the pleadings are complete.
Lordship, if I may. Lordship, she has been writing everyone, going to social media, which also has to be brought on record, post, and it is just because she has got a stay. So that we would like to put it on record.
There's no.
That has to be put on because she is otherwise the administration of AIMS has gone into total chaos because she, taking advantage of this thing, has been posting things on the social media, and it is not only limited to AIMS. It's gone to the ministry. She is talking about the Prime Minister's office. She is talking about the Prime Minister himself, personally.
Learned counsel appearing for the respondent AIMS submits that there is urgency in the matter in view of the fact that there's an interim order operating against the respondents. To stop, in fact, an application for vacating the interim order has also been filed. Considering the issue involved. Court is of the view that the entire matter be taken up for final disposal on a convenient date. We'll have a date. Accordingly, list the matter. It's a Thursday. List the matter on 10 September 2026 for admission hearing.
Lordship, in the meantime, she should reply to the show cause notice.
And that cannot be forced upon me, because I'm challenging the authority who has show cause. That the person whom I'm against complain against.
It is purely an administrative matter. Otherwise,
Let
Those things will be considered at on that date. We cannot say anything now, as of now.
my lord, the interim order may continue.
Interim order passed and shall continue to the next date of listing. Yes.
Obliged, so much.
My lord, the issue. My lord, I'm just placing this order. Actually, my lord, this whole bunch of this regularization matters, my lord, master worker and workers. It was hard in the coordinate bench, my lord, and some of the matters are fixed today. In that, my lord. So, my lord, actually,
This is what item number 34.
6.
no, my lord, this is an
Item 6.
this is an order, my lord, passed by a coordinate bench, my lord. What happened, my lord? These matters, my lord, they are 6, 8, 9, 10, 11, 12, 13, 28. These are all regularization matters, my lord. So, my lord, the issue was, my lord, hard for quite some time by a coordinate bench. And today it's fixed for, my lord, final disposal. Actually, my lord, it was supposed to be taken with those matters, my lord, but somehow, my lord, these matters came here.
Code number 18.
Code number 18, my lord.
Mr. Saikya.
My lord,
Matter has already been settled by the Supreme Court.
my lord, that is what, my lord, the thing is that what exactly we wanted is, my lord, the government, that if there is an uniformity order, my lord, it will be easier for us even for implement. Following, that is what division bench order.
Yeah.
So, my lord, my prayer would be, my lord, of course, my lord, it was to be, and this matter, my lord, our additional AG P Nayak is appearing. So, my lord, he will be appearing there. Dear my lord. So, my prayer will be, let this matter be adjourned for a week. Because, my lord, once an order comes out, my lord, because those are all
Okay, then we adjourn the matter then, Mr. Saikya. 1 week.
one week, my lord.
At the outset, Mr. Ardhar Lanet, additional senior government advocate, appearing for the Public Works Department, submits that similar matters are being taken up by the court number 18 today. And it is expected that those matters will be disposed of. He submits that the outcome of the said writ petitions would have an impact on these, on the instant matter, and therefore this case may be adjourned for a week. In view of above, list the matter. After a week, liberty of given to the parties to make a mention. This order will go in item number
6, 8, 9, 10, 11, 12, 13, 28.
6, 8, 9, 10, 11, 12, 13. After 13, 28.
28, my lord. Ajit Das. These are all same regulation matters. 17 also, my lord.
17 also. You got the sequence.
Same order.
Same order, by 9, 10, 11.
May I please, your lordship? Lordship, as per office note dated, my lord, we have received affidavit in opposition, my lord.
Respondent number 4 is filed.
Yes.
Who is respondent number 4?
Yeah.
Yes, I am, sir. Lordship, I am respondent number 4. government.
Okay, what about the others?
Lordship, no, Lordship, I am representing all the respondent here in this case, all the respondents.
Yes, are they not filing affidavit?
No,
Others?
Lordship, respondent number 4 is the appropriate authority that to file.
What is the issue?
Issue is departmental proceeding, Lordship, here in this case. So cause was on 17/11/2023, Lordship. Dismissal order, Lordship. Yes, page 39.
How do you say the DIG is the appropriate authority? Government should file.
No, Lordship.
DIG is not the government.
Lordship. What happened? Lordship?
Home Department should file.
No, yes, Lordship.
Police will give the parawise comments to the Home Department.
Lordship.
Home Department will look into the parawise comments, get the necessary vetting, and then you file the affidavit.
Yes, Lordship, what happened, Lordship? Here in this case, Lordship, what happened? The entire departmental proceeding was sought under the DGP, Lordship, the police, Lordship. That this is a matter of
Police is under the Home Department, Mr. Counsel.
Yes, Lordship. Yes.
Remember that.
Yes.
Why are you arguing like that?
Yes, Lordship.
The government has to file
An affidavit, Lordship.
an affidavit. DIG is filing it, that will not suffice.
Lordship, yes, Lordship. I will take that.
Whatever comments they have to make, they let them supply to the Home Department. Home Department will compile everything and file affidavit
Lordship.
to the government advocate.
Lordship.
Because this is not petitioner versus DIG. It is petitioners versus state of Assam.
Lordship.
That's why
Admitted.
Mr. J.K. Goswami, learned State Council, submits that although respondent number 4 has filed counter affidavit, he may be granted some more time for the remaining respondents to file their affidavit in opposition, and for which he pays for 3 weeks' time. Pay is allowed. List again on council.
Obliged.
None appears for the petitioner when the matter is called. 14.
Lordship, item 14, yes, Lordship, other side, Nalin Kohli sir is appearing, Your Lordship. They have taken consent, Your Lordship, from my senior yesterday for adjourning the matter, Your Lordship.
Correct, I know,
Lordship.
but nobody mentioned in the morning.
Lordship.
I was not going to dismiss it.
Lordship.
Anyway, please write like this. An adjournment slip has been circulated by the learned State Council seeking adjournment of the matter, and the same is not objected to by the other side. Accordingly, as the matter stands adjourned.
I place the adjournment. I, on behalf of the government, Lordship, pray before this honorable for adjournment.
Okay, accordance adjournment slip is there. On that basis, I'm giving.
That's right.
When do you want it? 2 weeks, 3 weeks?
Lordship, on 7th or 8th of September, Your Lordship.
Give a date.
Other matters are fixed on that. 7th.
Accordingly, list matter stands adjourned to be listed again on 7th of September.
The Lordship, one instruction received, Lordship, to wherein Lordship, it is categorically stated that regarding the disposal of the representation, Lordship, that was filed by the petitioner, Lordship. Today, it is fixed for a hearing. The petitioners is called before the authority to submit his relevant documents, Lordship. That is my instruction. Kindly fix the matter after, say 15 days, Lordship. It will be disposed of, Lordship. By the authority, Lordship.
This is regarding date of birth.
Yes,
Date of birth, yes. They have wrongly recorded a date of birth.
Please write at the outset, Mr. J.K. Goswami, learned State Council, submits that the petitioner has been called today for hearing, along with all the documents in support of his claim. About his actual date of birth. Stop. He therefore submits that the matter may be adjourned. How many days?
15 days, Lordship.
Fix a date,
Therefore, he submits that the matter may be adjourned for 2 weeks. Stop. The counsel for the petitioner, Mr.
Yes, Islam.
S. Islam agrees to the prayer in view of above. List again.
Lordship, I am appearing here in this case as a standing counsel, animal husbandry matter department.
Okay.
Standing counsel.
Instead of state counsel, you write SC and H and T. What is this?
This is my instruction also.
It's okay, keep it. With you.
Meet with the Lordship.
Yes, Mr. Dubey.
But here the petitioner challenges the impugned order dated 8/5/23, my lord. It's a order of compulsory retirement.
Okay. From which post?
Not from the post of my lord DGM, my lord.
DGM?
Yes, he was working under the FCI, my lord. That impugned order, your lordship find at
Pleadings are complete.
page 20. Yes, pleadings are complete, my lord.
And you are there for the FCI?
Yes.
Any other party involved?
No.
No, ma'am.
All right. We'll do one thing.
My lord.
I'll take 5 minutes break and come back.
Yes.
We'll start. Call the thing.
Sorry, you're not, item not 28. 28 was adjourned, your lordship, but 28 is a slightly different item, your lordship.
Huh?
28 matter, this matter relate to some of the work charge employee who has retired for pension and regulation of that. That is the issue is slightly different, your lordship. That's in the last order also it has been mentioned that way. Item 28, your lordship.
But Mr. Dhar had mentioned that these are all common matters.
No, your lordship, he has, without telling us, he has mentioned it. Because he said only Justice Unnikrishnan has referred in the order. He has said this is so and so. He has referred to so and so judgment is covered that way. So, lordship, see the order item 28.
No, we are on something else now.
You know, just I pointing to that because coming on the day, they are telling us they mention it and go away that way. Your lordship, they should inform us of.
Exclude item 28, okay?
Deeply.
Yes.
Meet with the Lordship. Kindly have a look at the summary of the case. my lord.
You have given me some judgment.
No, my lord, this is judgment as well as the summary of my case, my lord, sort of written argument, my lord. Just
Oh, this is your argument?
yes.
Okay. Why such a lengthy argument?
Lord, it contains both, my lord.
Runs into 9 pages.
Yes, not its summary of the case as well as not the proposition I am relying upon.
Yes, what is your case?
Well, we'll see. Lord, here I am challenging the order dated 8/5/23, my lord.
Page?
by which blood I have
Page number?
page 20, your lordship would kindly see. Annexure 1.
Page 20.
Yes.
Yes. You may read it.
Yes, whereas the undersigned is of the opinion that it is in the interest of the corporation and public interest in general to retired Sri Sushil Tirki DGN, presently posted at RO Assam Gauhati from the services of Food Corporation of India under Regulation 2.2 of FCI Staff Regulation. Now, therefore, in exercise of power conferred under the aforesaid regulations, the undersigned hereby retired Sri Sushil Tirki with effect from 8/5/2023. That in lieu of the notice period, Sri Sushil Tirki shall be paid a sum equivalent to the amount of pay and allowance for a period of 3 months, calculated at the same rate at which he was supposed to be drawing them immediately before his retirement. But against this, Lord, I submitted my representation, Lord, because your lordship sees
No, just a minute. Before that, this is what, compulsory retirement?
compulsory retirement. Lord,
What are you entitled to once you're compulsory retired? What is your entitlement?
my Lord, they are prematurely retiring me with your lordship has seen in lieu of 3 months salary. But I was retired, I was to retire in 2025. They have retired me in 2023.
Okay, question is again,
Hello.
what is your entitlement once you are prematurely retired? Do you get pension?
Lord, yes, I'll be getting pension.
You'll be getting pension.
Yes.
What do you lose? The service
Service.
of remaining 2 years, balance service not there.
Yes. And Lord, the resultant Lord, benefits.
2 years resultant benefits. On retirement, you get how much? 50% of your pay last drawn. That is the only entitlement.
Plus, Lord, it's a blemish on me, Lord, also, Lord, I'll say. Because the manner in which this
Is this a penalty?
is
Is it a penalty?
penalty as such, Lord, they have a power under their regulations to do, Lord. I'll come to that regulations.
What is the power?
My Lord, will straight away come to
In the impugn order, it has been cited somewhere.
Lord,
Regulation 22.
yes, regulation 22. Based on that, a circular has been issued that your lordship find at page 43.
43.
Yes. It's a circular dated 9 July 21. Has your lordship got, my Lord?
Yes.
My Lord will see periodic review of corporation employees for strengthening of administration under regulation 22 of FCI staff regulation. So this is basically based on their staff regulations.
So which is the particular regulation under which you have been
My Lord will
compulsory retired?
clause 10.
Board criteria
Yes.
to be followed by the review committee.
Yes, there has to be a review committee, my Lord.
To review what?
My Lord, the performance.
Your performance.
Yes.
So
Based on that-
depending on the desirability to retain you, they retain you. If not, you are okay.
Yes. No, that is. No.
Okay.
Now your lordship would kindly come to clause 10. Broad criteria to be followed by the review committee. The broad criteria to be followed by the review while making the recommendation are as follows. Corporation employees whose integrity is doubtful should be retired. This is one, my Lord. Second, corporation employees found to be ineffective shall also be retired. The basic consideration in identifying such corporation employees should be their fitness, competence to continue in the post head. Number 3, my Lord. No corporation employee should ordinarily be retired on ground of ineffectiveness if in any event he would be retiring on superannuation within a period of 1 year from the date of consideration. This is not applicable because 2 years hence I was to be retired.
Yes.
Number 4, my Lord, this is very important. No corporation employee should ordinarily be retired on ground of ineffectiveness if his service during the preceding 5 years or where he has been promoted to a higher post during that 5-year period, his service in the highest post has been found satisfactory. But I am relying upon this, my Lord. There is no such stipulation, however, where the corporation employee is retired on grounds of doubtful integrity. In case of those corporation employees who have been promoted during the last 5 years, the previous entries in the APARs may be taken into account if he was promoted on the basis of seniority cum fitness and not on the basis of merit. The entire number 5, Roman, the entire service record of a corporation employee should be considered at the time of review. The expression service record refers to all relevant records, and therefore the review should not be confined to the consideration of the apart dossier. The personal file of the corporation employee may contain valuable material. Similarly, his work and performance could also be assessed by looking into files dealt with by him or in any papers or reports prepared and submitted by him. It would be useful if the concerned internal committee puts together all the data available about the corporation employee and prepares a comprehensive brief for consideration by the review committee. Even uncommunicated remarks in the aparts may be taken into consideration. But this circular itself provided for representation, yet that your lordship finds at clause 13. And before that, clause 12, lordship would see the recommendation of the review committee will be put up for consideration and approval of appointing authority in those cases where it has been recommended to retire the corporation employee prematurely. So this was based on a review committee recommendation, which was approved by the appointing authority, and that's how I was compulsory retired. Now, not against that, there is a provision for submission of a representation that lordships find at clause 13. Representation.
You are relying upon this clause, regulation 10,
Yes,
sub-regulation 4.
my lord.
Okay.
5
Okay.
also, my lord, because it's a
4 and
matter of-
5.
Yes.
Okay.
And 13, my lord, I have also submitted a representation. After issue of the orders of premature retirement, the concerned corporation employee may submit representation against such orders within 3 weeks from the date of service of such order. And the matter may be placed before the representation committee along with fresh input, if any. The examination of the representation should be completed by the concerned personnel division within 2 weeks from the date of receipt of representation. The representation committee, considering the representation shall make its recommendation within 2 weeks from the date of receipt of the reference from the concerned personnel division to the appointing authority. The said appointing authority should pass its order within 2 weeks from the date of receipt of the recommendation of representation. My lord will also take note of clause 14 and 15. As per regulation 22A, if on a review of the case, either on a representation from the corporation employee retired prematurely or otherwise, it is decided to reinstate the corporation employee in service, the authority ordering reinstatement may regulate the intervening period between the date of premature retirement and the date of reinstatement by the grant of leave of the kind due and admission, including extraordinary leave, or by treating it as dies non, depending upon the facts and circumstances of the case. But this is when the representative, after submission of representation, they decide otherwise, my lords. Now, my lord, next proviso, provided that the intervening period shall be treated as the period spent on duty for all purpose, including pay and allowances. If it is specifically held by the authority ordering reinstatement that the premature return was itself not justified in the circumstances of the case, if the order of premature retirement is set aside by a court of law. So, my lord, if your lordships set aside this order, if my repetition is allowed, I am too entitled to get this benefit, my lord. Now, let clause 5.
Now, in your case,
My lord.
did you file representation?
Yes, yes.
What was the outcome?
My lord will see my representation as page 48.
What's the outcome?
That's one liner, my lord.
Rejected.
Yes, page 51.
So these are the provisions.
Yes.
If your representation is allowed, then you will be given leave to cover the gap.
My lord. And if a court of law, my lord, which I am before your lordships, if allows, plus I am also entitled to that, my lord. Now your lordships is page 51. Whereas Sri Sushil Chitri was retired from service of so-and-so, dated date 5. Whereas Sri Sushil had made the representation against the EBID order on dated so-and-so, which has been examined by the representative. Now, therefore, in exercise of powers conferred under the aforesaid regulation after careful representation and perusal, the undersigned hereby rejects the representation of so-and-so. So basically, they don't give any reasons, bloods, and it is only reflected on the record, and they have filed an affidavit, which basically deals with the reasons which, my lord, for which, my lord, I have been compulsory retired. Therefore, my lord, their affidavit becomes very important, my lord, which spells out, my lord, Otherwise, mean both the impugn orders, my lords, there is no reason, nothing.
What were you serving as?
DGM, my lord, general.
DGM.
Yes. I was promoted. So that 5 years, he should also come into play, my lord.
Deputy General Manager.
Yes.
And G stands for?
General Manager, Deputy General Manager, DGM.
Okay, Deputy General Manager. And that G stands for?
General, again general, my lord.
Again General.
There are several classifications.
Deputy General Manager, General.
General, yes, I am obliged. Now, if your lordships kindly take the affidavit in opposition, my lord.
You had the balance service up till 2025.
Yes.
Yes. Which month? Is it by age that it's counted?
Yes.
60 years?
Yes, 60. My lord, my date of birth has also been mentioned in the order.
In the order?
Yes.
Oh, yes. 66, January. That means January 2025.
Now, if your lordships take up the affidavit in opposition, my lord.
No, is there nothing else in the writ petition apart from what you've shown me?
No, my lord, there is no reason. My representation is there, my lord. Your lordship sees at page 43, my lord. Page 48. I have submitted a detailed representation, my lord.
One thing, did you amend the cost title?
No, my lord, it was not required because I am coming before your lordships after rejection of my representation.
No, but the reason I'm asking is because there are two cost titles similar. Page 1 and 2. Again, it starts to page 1 and 2. Single petitioner.
My lord, page 48, your lordship.
Is there any IA connected? No IA. Then how come it's repeated again and again? How many page 1 and page 2 do you have?
Only one, my lord.
I have 2 each. Page 1, 2, then it starts again 1, 2.
Some extra pages may have
No,
been
extra
added.
pages, okay. They seem to be similar. I think they're same.
Yes.
Hmm.
My lord, look
Then
at page 48, my lord.
48. Counter affidavit.
No, my lord, in my petition, my lord.
What is this?
My lord, my representation.
Okay.
But I have also annexed my APAR entries, my lord's annual report. But I rely upon their affidavit. But there it's tabulated, my lord. My petition, other documents are my APAR entries. There is no dispute as regard that. And they have been a tabulated form, my lord. They have also submitted.
Your representation.
Yes, page 48, my lord.
What did you say?
My lord will see. Clause from para 3, your lordship would see. That, sir, I was promoted to the post of DGM General in June 21, and on promotion, I joined Assam region and so and so. Since then, I've been working at FCI RO, and no adverse report remarks against my working have been received from any quarter. That, sir, you would appreciate the fact that my APAR grading from 1/1/2019 to 31/12/2000 was outstanding, which is a testament to my hard work, sincerity, and dedication to my work. I'm enclosing copies of the same for your kind reference and perusal. It is also to inform that my APAR for the period from 1/1/2022 to 31/3/23 has not been reported due to leave on medical grounds, and I am sure that my APAR for period so and so, which is yet to be, will be a proof of my hard work and dedication to duties. That, sir, I would like to mention that APAR for last 5 years are checked by the DPC at the time of promotion from AGM technical to DGM general, and thus even in 2021 my earlier APARs would have a minimum grading of good, and as such my promotion to the higher post was considered. That's the FCI headquarters circular 9721, which deals with the periodic review of the corporation employees under regulation mentioned in point number 10 that so and so, my lord has seen that no corporation or ordinary will retire. Let's sir, at the cost of repetition, in this context, I would like to reiterate that my APAR for the period so and so has outstanding grading, which is again a testament to the fact that the work performed by the undersigned in the promoted capacity of DGM General has at least been found satisfactory by my reporting and reviewing and accepting officers. Thus, the decision taken by your good self in violation of the above given guidelines for review under Regulation 22(2). Thus, at the cost of repetition, I would like to reiterate that my service records corroborate the fact that no adverse remarks from higher officers related to my work performance has been given. Rather, the appreciation of my work is the outstanding grading given in my FRs. Thus, sir, FCI headquarters circular stipulates the broad criteria to be followed by the review committee while making recommendation to your good self. Sir, with the utter shock and disbelief, I am unable to comprehend under which clause guidelines the review committee had recommended my name. While my performance has been judged outstanding, at the same time, no question has been raised on my integrity till date by any higher officer. Yes, sir, I had joined Assam region in July 21 and have been looking after the work allotted to me, including the crucial section of quality control. Sir, you might be aware of the investigations carried out in Assam region by headquarters just prior to my joining, which highlighted several irregularities in the OMR procurement. Being DGM quality of Assam region, I rendered my duty with due devotion in streamlining the CMR procurement process. And with great pride, I can state that no adverse observations have been highlighted subsequently, and paddy CMR procurement is going on smoothly in the region. Further, the undersigned has also worked as DGM SLTL at RO Assam with specific focus on regularization of pending storage and transit loss cases. At the time of my joining in August 21, the total pendency was 127.65 crores, and the same is only 3.96 crores presently. The huge reduction in the pendency itself speaks about the work performed by the undersigned. That's the manner in which the retirement order was issued for me under regulation so and so constitutes to make an opinion that the same has been done without following the existing guidelines. The order dated 8/5/23 does not even mention the grounds on which I have been retired. Had some deficiency in working been found observed, I should at least have been given an opportunity to explain my position in this regard. So in view of above summation, I would humbly request your kind self to reconsider the decision. Similar, even they don't pass any reasons.
This was on 15th of May, 2023.
Yes.
Then you filed writ petition in
23, but after rejection of my
August.
yes. Now, your lordship, kindly have a look.
See, one thing is that you were on leave on medical grounds.
A few days.
1 year and 2 months.
No. For some days I was there. In fact, they had not considered that, my lord.
See, come
That
to
is
page 48, your presentation.
Yes.
Paragraph 4.
Yes, my lord.
1/1/2022.
My lord.
To 31/3/2023.
My lord.
This is not few days.
No, my lord. During that, my lord, I was on leave, but this period has not been, my lord, my PAR was not upgraded at that relevant point of time. And my lord, this has no bearing in the decision-making process, my lord. It is also not reflected from the records and the affidavit which they have filed.
Okay, apart from the further period.
Yes.
Was not reported due to medical grounds. Not that you are on leave on.
Yes.
Okay.
Now, your lordship, kindly have a look at the affidavit in opposition filed by them. From para 11, up to 10, they have spoke about the circular guidelines, which they follow.
How many affidavits filed? Only one.
One.
You have filed a reply also?
Yes, I have filed a reply.
Okay. Yes, which part you want to show?
First, I'll start with para 9, my lord. That regulation 22(2) of the FCI regulations contain the provision for premature retirement of category 1 and category 2 employee after attaining the age of 50 years. And it confers on the appropriate authority the absolute right to retire any corporation employee by giving notice of not less than 3 months in writing or 3 months pay and allowances, even if his so-and-so service of post had entered corporation after he is attained the age of 55. But there is a exercise of assessing blood after attaining the age of 50. But that exercise has been done, blood, and subsequently I was promoted. So at that stage, blood, I was not compulsory retired, or blood, that assessment, blood, I have nothing negative against me. It is only, blood, in 2023, blood, when this exercise has been carried out.
Well, in the regulation,
Yes.
there is any
We will
prescription.
take assessment, blood. Once you complete 50, then 55. The impugn order is related to after completion of 55 years.
Assessment has been provided by way of age.
Age, yes.
Age in the
terms of
regulation.
Regulations, yes.
50
and 55.
55.
Yes.
Then there's no more assessment.
No.
Okay. I think this is prevalent in the judicial service
Yes,
also. Same things there.
Yes. My lord, kindly come to para 11, lord.
Yes, 11.
That the matter relating to the writ petition was reviewed by the review committee by following the guidelines contained in regulation so-and-so, dated so-and-so, and the FCI circular dated so-and-so. And thereafter, the review committee made the necessary recommendation to the appropriate authority, and accordingly, the order dated 8/5/23 has been issued by the managing director of the FCI. The broad criteria as laid down in para 10 of the circular were duly considered and followed by the review committee. The entire service record of the writ petition, including the charge sheets, penalties, apart grading, remarks about integrity, and the general reputation of the officer in the organization was duly considered and taken into account by the review committee. As such, there is no merit in the writ petition and the same deserves to be dismissed in limine. That the statement made in paragraph 8 of the are not correct and as such denied, as specifically denied the statements of the petitioner that the order dated has been passed mechanically by the MD of the FCI. In this regard, I further say that the order dated so-and-so has been passed only after thorough examination of the service record. At all relevant factors as set out in the aforesaid instructions, including judicial pronouncements of the judgments, have been duly taken into consideration and the prescribed procedure has been meticulously followed. It is settled legal position that orders of compulsory retirement are not required to be speaking orders. The basic spirit of the guidelines is that the order of compulsory retirement shall be based on bona fide opinion and subjective satisfaction of the competent authority, and it is in public interest. That it is stated that while dealing with a matter relating to compulsory retirement in the case of Rajasthan State Transport Corporation and so-and-so, the Honorable Supreme Court by the judgment dated so-and-so as category held at, it hardly needs to be emphasized that the order of compulsory retirement is neither punitive nor schematic. It is based on subjective satisfaction of the employer, and a very limited scope of judicial review is available on such cases. Interference is permissible only on the ground of non-application of mind, mala fide, perverse or arbitrary, or if there is non-compliance of statutory duty by the statutory authority. There is no dispute as regard the proposition of law, my lord, of this judgment. Power to retire compulsory the government servant in terms of service rule is absolute, provided the authority concerned form a bona fide opinion that compulsory retirement is in public interest. But now we are testing whether forming that bona fide opinion based on what the material says and has been shown to your lordship is legal or not. That's para 15, that the statements made in para 10 of the receive and express borne out for the are not true and correct and the same are hereby. In this connection, I say that clause 10(5) of the circular dated states that the entire service record of a corporation employee should be considered at the time of review. The expression service record refers to all relevant records, and therefore the review should not be confined to the consideration of the apart dossier. The personal file of the corporation employee may contain valuable material. Similarly, his work and performance could also be assessed by looking into files dealt with by him or in any papers or report prepared and submitted by him. It would be useful in the concerned internal committee puts together all the data available about corporation employee and prepares a comprehensive brief for consideration by the review committee. Even uncommunicated remarks in the parts may be taken into consideration. Therefore, I say that while passing the order dated so and so, the appropriate authority, that is the MD of the FCI, the entire service record of the writ petition has taken into consideration, and it was not confined to a part dossier only. That the statement made in so and so, say when experts borne out from are not true and correct. I say that the petitioner was promoted to the post of Deputy General Manager in accordance with the procedure of promotion. However, it is stated, not admit this that I was promoted. It is stated that the petitioner was graded fair during 2013. While working with other 7 different controlling officers, he was barely graded at the minimum benchmark grading good to keep his promotional avenue open. A copy of extract of APAR's grading of the writ petition is annexed herewith. My lord will see my one of the grading is fair in 2013, my lord, and they have selectively taken it to be, my lord, representing my performance, my lord. My lord, straight away, if your lordships kindly come to page 95, my lord.
$95.
Yes. Annexure D of their affidavit in opposition.
Yes.
My lord, they have tabulated my performance, my lord, from 97 onwards, my lord. It's in descending order, your lordship has seen. It starts from 21. My lord, first column, period your lordship sees 21. It is outstanding. Integrity is sound. Again, outstanding. Last 3 entries are outstanding. So far as integrity is concerned, sound, nothing adverse, sound, trustworthy, beyond doubts. And my lord,
What about 12?
yes, very good oblique fair. My lord, we have also clarified this. But one fair is there. But it is a representative of my entire service record, my lord. That is what they have pinpointed it, my lord.
But how does it go together with very good and fair?
But it's there's 2 period that has been divided. Actually, there should not be very good here. There is one good and fair for the part. In our reply, we have clarified. My lord, you'll see
What is the
2 apart available in dossier.
2 APARs? What is the duration under which these 2 APARs are covered?
My lord, will see 11 and 12. From January 2013 to April 2013, and its annual, my lord, starts from January and in December.
And what is NRC?
No report certificate, my lord.
I see.
Your lordship has seen that one fair entry had gone into the mind of the authority for making me compulsory retired, my lord. Even in the next page, your lordship sees my earlier years entry, my lord. Only one average is there in 2002, my lord. And so far as my integrity is concerned, there is no adverse entry. And I'll show to your lordship how they have interpreted even the entry in my integrity column, my lord. So they selectively take into consideration only one fair, that is in 2012, not 13. Now, lordship, kindly come to para 17 of the affidavit. The statement made in paragraph just 7 is when the statement borne out of the are not true and correct, and the same at the end. In this regard, I say that clause 4 of the circular dated so and so, which has been quoted here in blood. The word ordinarily in the above clause clearly suggests that the competent authority is not completely precluded from passing orders of compulsory retirement under regulation 22(2) of the staff regulation if the employee was promoted during the last 5 years. Moreover, the second part of the clause further clarifies that the employee was promoted during the last 5 years on the basis of seniority cum fitness and not on the basis of merit. The previous entries in the parts can be taken into consideration. The case of the writ petition is clearly covered in the second part of clause 10 Roman 4 of the circular dated so and so, as the promotion of the petitioner was made on the basis of seniority cum fitness and not on the basis of merit as per the standard policy followed in the corporation. Even then, blood seniority cum fitness, blood I have fit enough blood for promotion. That the writ petitioner is not entitled to claim any benefit under clause 10.4 of the above circular, even if he was promoted during the last 5 years and is apart for the period July 21 was graded outstanding as averred in the para under reply. The competent authority has rightly taken into consideration the entire service record of the writ petitioner and other relevant factors envisaged under clause 10 of the circular. Therefore, I strongly deny that the statement of the petitioner that the decision taken by respondent number 2 is in violation of the above guidelines under regulations. Now, my lord, para 18 sum up, my lord, what is the basis of their decision-making process. That the statement made in para 12A of the writ petition are not wholly correct, and as such, they are denied by me. In this connection, I say that vigilance and administrative profile of the petitioner reflects the following. Number Roman column 1, the petitioner was charge sheeted under regulation 58 of the staff regulation by memo number so and so issued by the managing director of the FCI, and he was imposed the penalty of reduction in the time scale of pay by 2 stages for a period of 3 years and shall not earn increment during the period of such reduction. The penalty shall have effect from postponing further increment of pay. But these are the administrative actions that has been taken, my lord, against me. The petitioner was charge sheeted under regulation 60 by memo number so and so, and he was imposed penalty of withholding of 1 increment for a period of 1 year without cumulative effect, wide order dated so and so. The petitioner was charge sheeted under regulation 58 of the staff regulation issued by MD of the FCI, and he was imposed penalty of stoppage of 1 increment for a period of 1 year without cumulative effect. The upper grading of the petitioner also reflect that he was graded as fair during the year 2013. And while working with other 7 different controlling officers, he was barely graded at the minimum benchmark. So they have picked only 1 grading block. His integrity during the year 2012 was not recorded by his controlling officer and also not clearly certified as beyond doubt by his 7 controlling officer. Rather, it was stated nothing adverse came to notice, which cast serious doubt on his fitness to be reconsidered for continuations in service. But in our full submission, but this proposition is not correct. But something which is not negative against me cannot be interpreted in a negative manner. The committee also took inputs from personal file field officer on general reputation of the officer, and the same was not found satisfactory as far as his performance and integration is concerned. But they don't disclose what is the materials. But in fact, pursuant to your lordship's order, my lord, my learned friend has produced the records before your lordships, and my lord, I was also permitted to peruse the same. But whatever is contained in this affidavit is basically based on the records, and there are no materials which I could see, my lord, so far as clause number Roman 6 is concerned. My lord. That para 19, my lord. So basically, these are guidelines specific. And Mr. Ramachandran Raju's judgment has been quoted, where it has been said the officer would live by reputation built around him. In an appropriate case, there may be sufficient evidence to take punitive disciplinary action of removal from service, but his conduct and reputation is such that his continuation of service would be a menace in public service and injurious to public interest. The entire service record or character rules, confidential reports maintained would furnish the backdrop material for consideration. But with due respect, my lord, this proposition is not applicable because it's not a case. My lord, you have graded me outstanding for last 3 years, promoted me in last 5 years. Do I deserve this, my lord, that I don't deserve to continue, my lord? So this has no applicability in my case, my lord. This is my response submission. Para 20, my lord. In this case, I say that the plea of the petitioner that procurement in Assam during his was going on smoothly, where his predecessor has is completely irrelevant and misplaced. But this is my functioning, my lord. How you assess me and how it could be so irrelevant? Where I have improved, my lord, the losses It is not necessary that irregularities committed by an officer are discovered during his tenure itself. In many cases, sir, they will come to the surface when the incumbent is transferred to some other place or post. But so far as I am concerned, my lord, there is nothing that has come up against me. And Lord, it says similarly, reduction in pendency of storage and transit loss cases for regularization for joining Assam is hardly of any relevance. But that should be at least fair enough that I have done a good job, my lord. My lord, again, my lord, the Union of India and Colonel J. Sinha has been cited, my lord. Now coming to express words of Fundamental Rule 56, it says the appropriate has the absolute right to retire a government servant if it is of the opinion that it is in the public interest to do so. The right conferred on the appropriate is an absolute one. The power can be exercised subject to the conditions mentioned in the rule. One of which that the concerned authority must be of the opinion that is in public interest to do so. If that authority bona fide forms that opinion, the correctness of that opinion cannot be challenged before courts. It is open for an aggrieved party to contend the requisite opinion has been formed or the decision is based on collateral grounds or that is an arbitrary decision. But even in subjective satisfaction, Lord, your lordships has the power of judicial review, Lord. Now, my lord will kindly take note of para 23, Lord. That the statement in para 17 of the writ petition, save and accept the statement are not true and correct, and the same are denied. In this, can I say that the guidelines relating to premature retirement nowhere stipulate that only those employees whose names appear in doubtful integrity list or agreed list can retire under regulation. But at least my name doesn't appear, my lord. The averment of the petitioner that for the current year, the petition had not been either of the two, so his name had appeared in the averment in the past. But it is for them to say, my lord. I can only deny, I cannot prove a negative thing, my lord. Lord, in para 24, my lord, they have quoted para Roman 5, my lord, relevant to entire service carrier, page 67, lordship would see. Therefore, I say that the petitioner has been compulsory retired by the order dated 8/5/23 by the managing director only after proper examination of his entire service record and in accordance with the rule based on bona fide opinion and subjective satisfaction of the competent authority in the interest of corporation. Milord, again, MS Bindra has been cited, Milord, in para 26.
Was it about?
Milord, will see at page 68, Milord, the proposition. If integrity of senior officers, has your lordship got something in the middle? If integrity of senior officer who establish unblemished reputation and encomiums from all concerned till then is proclaimed as doubtful, merely on the strength of statements of persons prosecuted by such, what is the safety of such, more so when they have to embark on hazardous operation risking their lives against big business. In the instant case, the petitioner has made no specific allegation or malafide or ill against the competent. I need not make. From the records, it will be revealed. Rather, the proposition supports my case, milords.
We have, relying on this case, we have distinguished.
Bindra. Bindra is read by him.
By the petitioner.
My lord.
Then why is it next in the affidavit of position?
Right. Impressive, your lordship, but this is not applicable because the facts are different in that case and in the present case. Ultimately, in the instant case, the petitioner has made no specific allegation of malafide or ill will against the competent authority and or the members of the committees and or the outsider influencing the officers concerned to settle scores against him.
But they have
That
totally,
says in the MS Bindra.
totally taken in a different way, my lord. But my contention before your lordship was that a mere statement by some third party, my lord, will not damage my reputation as such. This is the ratio, my lord. The FCI says that I have not made any specific allegations. Since there was nothing, no reasoning, what I can say is that I can put up my case before your lordship, saying that there are no adverse comments by anybody and nobody can damage me in the manner if they want to do in this way. So having not denied that and have come in a different way saying that I have not made alleged malafide against somebody, it's basically established my case that there is nothing on record by any individual or so against my reputation. Because your lordship has seen the judgment, even other unconfirmed statement or records would also, my lord, go against me if it is against me.
Yes.
But again, at para 30, they have reiterated, my lord. At page 70, they say that it has been filed, the order has been passed bona fide and due application of mine. Yes, para 30. Now. Lord, para 29 lordship would also seem, Lord. I missed that, Lord. That the statement made in para 24 of the writ are not correct and even denied. In this kind, the petitioner is put to strict proof of the allegations so made. I say the representation data of the petitioner was forwarded to the representation committee, and the committee observed that the contentions raised by the petitioner were not on sound footings, and in the entirety of the matter, the committee found no concrete ground to differ with the observation of the review committee. Further, as clarified in the preceding paragraph, there is no legal requirement of proper notice or passing speaking order. As such, the remedy of making representation against the order of compulsory retirement cannot be termed as empty formalities or eyewash merely on the ground that the representation of the petitioner has been decided by a speaking order.
This, what is this CSN Murthy? They have relied upon CSN Murthy.
My lord.
Next page.
Yes. An order of 92 is similar. A compulsory there is not an order of punishment. Fundamental Rule 56J authorizes the government to review the working of its employee at the end of their period of service, refer to therein, and to require the servants to retire from service if, in its opinion, public servant interest calls for such an order. Whether the conduct of an employee is such as to justify a conclusion is primarily for the department authority to decide. The nature of the delinquency and whether it is of such a degree as to require the compulsory retirement of the employee is primarily for the government to decide upon. The courts will not interfere with the exercise of this power if arrived at by bona fide, and on the basis of material available on the record. We also don't dispute this proposition. The exceptions carved out is whether it's bona fide and on the basis of material available on the record. Our contention before your lordship is the materials which they have relied upon doesn't warrant that I should be compulsory retired.
What is that material?
Now, these are the material which they have spelled out, that my fair grading, 3 punishments that has been meted out to me.
That punishment was on which year?
2000, let's see, 12, 16, 13. And para 18 they have given at page 61 if your lordship comes.
61.
And none of it, these are all administrative actions, milords. Nothing has to do with my integrity. So it was basically a common lapses on the part of combined officials, milords. No, blood. With due respect to my learned friend, milord, integrity is something far more than what they have. Para 18 lordship sees Roman 1, order dated 11/3/2014. Roman 2, order dated 26/7/16. And para 3, milord, order dated 5/12/2019. Milord, if my integrity and if this punishment can be interpreted as mean it affect my integrity, milord, this has to be there in that annexure D column, milord. And I would not have been promoted in 2021, milord.
Somewhere they say your promotion must not on merit.
Fitness, milord. That integrity would also come into play, milord. And your lordship sees the column in the integrity column. Again, I'll draw your lordships at page 95. It was on seniority come fitness. So fitness would, milord, integrity is part of a fitness, milord. Now, lordship, for a moment again come to page 95, milord. Now your lordship specifically
nothing adverse.
Yes. Then integrity is sound in 21. Sound, nothing adverse reported. Sound, trustworthy.
No, nothing adverse has been interpreted as what?
As milord, there is something.
Serious doubts.
Yes. Something which is positive for me, my lord, they try to interpret in a manner that it is negative for me. My lord, lordship would kindly come to page 71, my lord.
71.
One is part of para 31. In this regard, clause of the FCA state that the entire service record of a corporation employee should be considered at the time of review, and that review should not be confined to the consideration of a part dossier only. But I also reiterate that you look into my entire service career, not only year 2012 and 13, my lord. It is also stated, and in even uncommunicated remarks may be taken into consideration. But there is nothing uncommunicated adverse remarks so far as I am concerned, my lord. They have not put anything on record, even though the record also doesn't spell out anything. I further say that the orders dated so and so have been passed by the appropriate authority after thorough examination of the entire service record, which include the vigilance and administrative profile of the petitioner. Therefore, I say that the grounds taken by the petitioner are not valid grounds in the eye of law to file the instant writ petition, as the law laid down by the Honorable Court of India in a catena of judgment does not permit judicial intervention unless the petitioner is able to establish that the order of has been passed with mala fide intention and not in public interest. My lord, will see it's only not two aspects. There is perversity is also there, my lord, I'll show. My lord, will see this judgment, which I also rely upon. In this regard, I rely on the principles summarized by Honorable Supreme Court in the case of Vaikuntha Nath Das and another was the Chief District Medical Officer Baripada, 92%, which is reproduced below, my lord. But I am also relying on this. An order of compulsory is not a punishment, implies no stigma or any suggestion of misbehavior. The order has to be passed by the government on forming the opinion that is in the public interest to retire a government servant compulsorily. The order is passed on the subjective satisfaction of the government. But even the subjective satisfaction is Lord. Principle of natural justice have no place in the context of an order of compulsory retirement. This doesn't mean that judicial scrutiny is excluded altogether. While the High Court or this court would not examine the matter as an appellate court, they may interfere if they are satisfied that the order is passed on mala fide or it is based on no evidence and that it is arbitrary. Lord, I am here on B and C, Lord, in the sense that no reasonable person would form the requisite opinion on the given material. In short, if it is found to be a perverse order. Milord, if I have an outstanding rating for last 3 years, I am promoted, Milord, and do I deserve this? This is the test of a common man, Milord. The government or the review committee, as the case may be, shall have to consider the entire record of service before taking a decision in the matter. Of course, attaching more importance to record of and performance during later years, Milord. This is very, very relevant, Milord. You have to give more emphasis on the later part of your service, Milords, immediately preceding my compulsory retirement. How was it? The record to be so considered would naturally include the entries, the confidential records character roles, both favorable and adverse. If the government servant is promoted to a higher post, send the adverse remarks. My lord will see such remarks lose their instinct more so if the promotion is based upon merits and not upon seniority. An order of compulsory retirement is not liable to be quashed by a court merely on the showing that while passing it, uncommunicated adverse remarks were also taken into consideration. The circumstance itself cannot be a basis for the interference.
Okay, Mr. Dubey, and we'll come back to.
The thing is that, my lord, in this case, my learned friend has read out the affidavit in opposition. My party is also complete. Only thing is that, my lord, I am led by Mr. Kane Chaudhary, senior advocate, my lord. So he is in court number 1, my lord. So he has requested me to request your lordship to take to hear him on some other day, Thursday, my lord, for brief 15 minutes.
And that can be well, sure, we'll see. Let him complete his.
Yes, my lord.
In fact, he's doing everything for you. He's
Yes, my lord, that's what
he's
I
mainly
submitted.
reading the counter affidavit.
That is where the entire decision-making process has been reflected.
Now he will read the writ petition.
There could be
Changing sides.
not more, my lord, because both orders are unreasoned orders.
For pronouncement of judgment, item 1, criminal appeal jail 45 of 2025 pertaining to Aizawl bench.
Page 18. For the reasons assigned, the impugned judgment and order is found to be unsustainable and the same is set aside. The appellant is directed to be released unless wanted in connection with any other case. For the valuable assistance rendered by Mr. Jordan Rohingthanga, learned amicus curiae, he shall be paid fee as prescribed by the Mizoram State Legal Service Authority. Registry shall return back the TCR to the trial court concerned.
I'm so grateful, my lords.
Yes, Mr. Duke.
Come to page 73, my lord, the affidavit.
Yes.
I am referring to which the judgment they have referred, State of Gujarat versus Umaid M. Patel, reported in 2001 3 The state principle relating to compulsory return have further been crystallized in the definite principles in paragraph 11 of so and so, which are enumerated. When the services of a public servant are no longer useful for the general administration, the officer can be compulsorily retired for the sake of public interest. Ordinarily, the order of compulsory retirement is not to be treated as punishment coming under Article 311 of Constitution. For better administration, it is necessary to chop off dead wood. Basically, this is the main objective, my lord. But the order of compulsory retirement can be passed after having due regard to the entire service record of the officer. Any adverse entries made in the confidential record shall be taken note of and be given due weightage in passing such order. My lord, it says about due weightage, my lord. So any entry, if at all, that fare has a due weightage vis-a-vis the other entries also, my lord. It can't be a sole consideration. The order of compulsory retirement shall not be passed as a shortcut to avoid departmental inquiry when such course is more desirable. If the officer was given a promotion despite adverse entries made in the confidential record, that is a fact in favor of the officer. So, my lord, the judgment which they have cited, my lord, in fact, they have not applied their mind to that. And, my lord, in my reply, my lord,
So what do you gather from the various principles
my lord,
enunciated by the apex
they
court?
can do it, my lord.
It can be done. It's not a punishment. It's not a
Not a
penalty.
punishment, they can done it. But, my lord, it should not be malafide and it should not be perverse and it should not be without any basis. My lord, there has to be reasons, my lord.
There has to be reasons. They have given about 4 or 5 reasons.
Yes, my lord, whether, my lord, that reasons would suffice. My lord, this is the question before your lordship. My lord, in fact, in my reply, my lord, I have indicated everything which I have made a submission before your lordship. But that, so far as proposition is concerned, there is no dispute at all. What they are doing it, Lord, selectively picking and choosing, my lord, which suits them. It speaks of entire service record, but they are seeking only one entry. My lord, more weightage is to be given to the recent, my lord, they are giving it to the past. And my lord, the judgment has also said that if later on he has been promoted in spite of those entries, my lord, that should be redundant, my lord. So, my lord, seeing from this perspective, my lord, it's not a case where, my lord, I should have been compulsory retired.
So they have seen only the bad side of you.
Yes, yes.
They have not seen the good side of you.
Good side of it. Rather, they don't want to see, my lord. But I have given a note, my lord. Just I'm laying down the proposition if your lordship will see.
Yes.
In the first page, my lord, I have indicated about the orders that I have challenged. And what is the requirement? It is a 1.2. An order of control can be interfered with when it's malified based on no matter arbitrary or perverse. So in this case, my lord, it's an arbitrary and perverse. And my lord, in clause 2, second page, my lord, undisputed emerging from the record, my lord, there is no dispute as regard this, that when I joined services in 1997 as manager technical, thereafter I was promoted to AGM, and then to DGM on 25/6/21, my lord. And my lord will see in clause 2.2, the abstract of APAR gradings placed on record by the respondents themselves at Annexure D to the affidavit shows that across roughly 30 gradings on record, the petitioner has received 5 outstanding, 11 very good, multiple good, and only one that is which they are harping on. And so far as integrity is concerned, it's been uniformly described as sound, beyond doubt, trustworthy, reliable, morally sound, unquestionable, nothing adverse. And nothing adverse they are interpreting, and that too way back, as if some adverse is there against me. And 2.3 I've said as regard my recent integrity record, my lord, and still they accept it, my lord. And my lord, 2.4 is based on their affidavit as well on the record. The same thing appears, my lord. What are the para 18 of that affidavit would indicate the 3 prior disciplinary proceedings one solitary fair grading, and absence of any integrity mark for the year 2012, and nothing remarked. But I have also dealt with this not in my issue in the ground. And I have submitted in 2.5 the representation which has been not considered, single line. Now, your lordships, in Roman 3, my lord, I have raised the issues, my lord, which your lordship has to decide. Whether the impugned retirement order is vitiated by direct violation of clause 10, Roman 4 of FC, inasmuch as the petitioner was promoted to DGM within preceding 5 years. Whether the review committee's decision suffers from non-application of mind, selective and perverse appreciation of the service record, and thus fails the test of subjective satisfaction enunciated in Bekun Nadas and Umed Bhai Patel. Those have been quoted. I am also carrying the judgment. I'll place before your lordship. Those are relevant paragraphs that has been quoted of both these judgments. Whether the impugned rejection order is a non-speaking mechanical order that reduces the statutory representation mechanism under para 13 of the circular to a mere formality. Whether cumulatively the impugned action is arbitrary, unreasonable, and violative of Article 14 of the Constitution. But based on these issues, my lord, I have formulated my argument as under, my lord. Ground 1, the impugned retirement order directly violates clause 10 Roman 4 of FCI. I have quoted at 4.1, my lord, and I have indicated, my lord, when what is his gradings and aparts, my lords. Clause 4.3, your lordship would see next page. The respondent seeks to escape the plain language of clause 10 Roman 4 by contending in para 17 of that the second part of the clause permits reliance on earlier apart entries where promotion was on the basis of senior command. That construction is untenable for 3 reasons. The second part of clause Roman 4 applies expressively and only to cases where the employee is being retired on grounds of doubtful integrity. So that has to be read together, my lord. The review committee minute do not record a finding of doubtful integrity. Rather, they refer to phrase such as nothing adverse came to notice. Not one controlling officer over 3 decades of service has recorded the petitioner integrity as doubtful. On the contrary, the record entries are sound, beyond doubt, trustworthy, reliable, morally sound, unquestionable. The petitioner's name does not appear in the agreed list or the doubtful integrity list for the relevant year. He has never been investigated by CBI, ED or the police. There is no property complaint, no vigilance case pending, no serious property transaction contemplated by paragraph 12.2 of the Deputy OM. Even assuming without considering that reference to earlier apparts was permissible, the earlier apparts themselves overwhelmingly disclose very good and outstanding grades with unblemished integrity remarks. A solitary fair of 2013, followed by promotion to DGM 2021, cannot on any reasonable view displace the express bar in clause Roman 4. Not interpreting word ordinarily in clause 10, Roman 4, has been given a specific meaning by the very DOPT OM, which the circular incorporates. The exception is confined to a sudden and steep fall in competence, efficiency, or effectiveness. Far from a sudden and steep fall, the petitioner trajectory is one of sustained ascent, 3 back-to-back outstanding apparts, and a fresh promotion. The review committee's action is therefore in direct contravention of the guidelines it professes to follow. Milord, now ground B is on the subjective satisfaction, Milord, is vitiated by selective and perverse appreciation of the service record. The Honorable Apex Court in Vaikuntha held that a compulsory round can be interfered where it is based on no evidence or arbitrary, in the sense that no reasonable person would form the requisite opinion on the given material. Well, this is the line. If a government servant is promoted to a higher post, notwithstanding the adverse remarks, such remarks lose their sting. Now in 4.6, Milord, your lordship would see what are the grounds that they have taken. The 3 disciplinary proceedings penalties, each minor in character and unconnected with integrity, which my learned friend was saying that it reflects integrity, which is not correct, Milord. Predated the petitioner's promotion to DGM General on so-and-so. The department promotion being seized the entire service record, still found him fit for promotion. Those penalties have therefore lost their sting in the language on Bakuntnathas. The 2013 fair grading is a solitary aberration in a 26-year sea of good, very good and outstanding entries, and even that period simultaneously carry a very good grading in companion appar available in the dossier. The review committee has drawn an adverse inference from the phrase nothing adverse came to notice in the integrity column of certain older apparts. This is a standard benign departmental expression contemplated by the DOPT OM dated so-and-so, to convert a neutral entry into a positive indicator of doubtful integrity while ignoring express certifications of sound beyond doubtful in the very same dossier is the classic definition of perversity. So, my lord, they fail to see all those greetings, only their eyes stick to like word of Arjun's arrow, my lord. Only fair they can see, nothing else. The Honorable Supreme Court caution in MS Bindra, your lordship kindly see. The maxim nemo firut trepentopolis, no one becomes dishonest all of a sudden. The authorities should not keep their eyes totally closed towards the overall estimation in which the delinquent officer was held in the recent past by those who were supervising him earlier. To dunk an officer into the puddle of a doubtful integrity, it is not enough that the doubt fringes on a mere hunch. Next, my lord, an officer graded outstanding by the CMD of the very corporation on 21/3/2022 cannot lawfully be labeled as a person of doubtful integrity by the same CMD on 8/5/2023. Your lordship would see the time frame only 2 months, my lords, 13 months, my lords, without any intervening material. There is not a single fresh complaint, vigilant report, proprietary inquiry, or adverse remark cited by the review committee that postdates the outstanding APAR of 21. The subjective satisfaction is on the committee's own materials, manifestly unreasonable. And ground 3, Lord, the entire service record was not in fact considered. The respondent have themselves been selective. Now, Lord, their own circular says that consideration of the entire service record. In para 15 of the affidavit in opposition, the respondents piously invoke this clause, yet the review committee's meeting disclosed that the committee marked selectively passed. What is that? Outstanding, they have ignored outstanding APARs. Appreciation letter issued by the CMD, we have annexed in our reply. The streamlining of CMR procurement in Assam, they say it's not relevant. The fact that the petitioner's name has never been featured in doubtful integrity. And next is the selective consideration. As the apex court held in K. Kandaswamy versus Union of India, the opinion must be based on the material on record. Otherwise, it would amount to arbitrary or colorful exercise of power. So, there are so many things on record, and they don't form opinion on basis of this. Therefore, it becomes colorable exercise, milords. The respondent's affidavit in opposition itself telegraphs the arbitrariness. Paragraph 16 highlights only the fair grading of 2013, while paragraph 18 relies on penalties that predate the promotion. Not a whisper is offered on the outstanding APARs from 19 to 21 or the tangible service achievements in Assam region. This is precisely the colorable exercise of power that Kandaswamy condemns. On the last ground, next ground, the impugn order, rejection order is mechanical, non-speaking order that renders the statutory representation mechanism illusory. What we say is, once we submitted a representation, they were bound to give a speaking order, my lord. Paragraph 13 of the circular confers on the retiree a right of representation to be considered by a duly constituted representation committee within stipulated timelines. Where a statute or a binding administrative instructions provides for a representation, the consideration must be real and not ritual, which is in the present case. The representation committee report dated 19/6/23 is a single paragraph. It records no reason, no engagement with the 12 substantive grounds urged, no examination of the outstanding APARs, no analysis of clause 10 Roman 4. The impugn rejection order dated so and so, this bare recommendation. The pattern of the review, recommendation, and rejection orchestrated within weeks and each documented by a single page unwritten note established a predetermined mind, lord. Even accepting the respondent's contention, paragraph 29 of the affidavit, that a speaking order is not strictly required at the retirement stage, the position is different at the representation stage. Once a right to make a representation is conferred, its non-speaking rejection deprives the aggrieved employee of a meaningful protection and the court of any material against which the test, the bona fide opinion mandated in Colonel J. N. Sinha. The impugned rejection order therefore fails the test of fairness amended. Well, that is the precise reason there is nothing in my petition, because there is no speaking order, nothing. Lord, I come to ground 5 is important, Lord. Your Lordship has seen for one period. Absence of an integrity record for 1 year cannot be weaponized against the officer. Ground number 5 in para 18 of the affidavit and paragraph 3 at page 3 of the review committee hold against the petitioner the fact his integrity during the year 2012 was not recorded by his controlling officer. Lord, is it me who has at fault, my lord? This is legally untenable. The recording of an integrity in the duty is the duty of the reporting officer, not the officer reported upon. Non-recording by the reporting officer cannot be visited on the petitioner. DOPT OM dated 11 to 16 specifically requires a positive entry. Its absence is a lapse of the reporting officer, not evidence against the assessee. So if there is nothing, that cannot be taken against me, my lord. Every other year in the petitioner service dossier carries a favorable integrity entry. And the controlling officers who wrote nothing adverse were in fact certifying the absence of adverse material, a positive statement in favor of the officer, not against him. And the next ground, my lord, the circular dated read against DOPT so-and-so in the Supreme Court jurisprudence. Where the respondent's own reliance on Umed Bhai Patel is a self-defeating. That case laid down, my lord, I have read, my lord, the officer was given a promotion despite adverse entries made in the convention. That is the fact to favor of the officer. Compulsory retirement shall not be imposed as a punitive measures. Well, it's undisputed fact that he was promoted in June 21, despite the disciplinary record now sought to be paraded against him. So basically, the impugned action in these circumstances, my lord, becomes a punitive exercise by the department against the petitioner, my lord. My lord, I have also relied upon Ramchandra Raju, which the respondents also rely, that the conduct and reputation is such that his continuation in service should be a menace to public service. Now, this is the public interest test, my lord. But does the gradings, his conduct justify that he is a... So, my lord, they have failed to assess this aspect of the matter, my lord, with a predetermined that he should be thrown out, and he has been done so. So, my lord, ground 7 is the cumulative of all these grounds, my lords, which they have failed to take note of, my lord. Referring to some movements now. My lord, so it has been referred and quoted, my lord. The first one is Vaikunth Nath Das. I will not take your lordship's much on the issues, my lord. My lord will kindly come to para 17, my lord, where the conclusion part, my lord, para 32 in this judgment.
Paragraph 32.
Yes. And this has also been in the affidavit your lordship has seen, my lord.
Regarding?
Lord, what are the parameters, my lord? It has been, the law has been settled in this case, my lord, and these principles are still being followed.
Parameters for compulsory retirement.
Yes, yes.
Para 32.
Para 32.
Yes.
Well, an order of compulsory retirement is not punishment. It implies no stigma or suggestion of misbehavior. The order has to be passed by the government on forming an opinion that is in the public interest to retire a government servant compulsory. The order is passed on the subjective satisfaction of the government. Principle of natural justice have no place in the context of an order of compulsory retirement. This does not mean that judicial scrutiny is excluded together. My lord will kindly take note of this. While the High Court or this court would not examine the matter as an appellate court, they may interfere if they are satisfied that the order is passed mala fide or that it is based on no evidence or that it is arbitrary in the sense that no reasonable person would form the requisite opinion on the given material. In short, if it is found to be a perverse order, I am relying upon this paragraph. The government or the review committee, as the case may be, shall have to consider the entire record of service before taking a decision in the matter. Of course, attaching more importance to record of and performance during the later years. My lord. This is also important. Later years, I had 3 outstanding gradings and I was promoted, my lord. Still, they rely upon that fair and the departmental proceeding initiated many years back, my lord. An order of compulsory is not liable to be passed by a court merely on the showing that while passing it uncommunicated adverse remarks. No, these are not my case, my lord. Interference is permissible only on the grounds mentioned. This object has been discussed in para so and so. So, my lord, these parameters also, my lord, they have correctly stated the proposition of law. The flaw is in the implementation. They have not adhered to the principles which have been enunciated. Similar is MS Bindra case, my lord. The maxim I have quoted in my written argument, my lord, para 13, your lordship would say.
Para 13 of this judgment.
Yes. While viewing this, your lordship got it.
Yes, yes.
While viewing this case from the next angle for judicial scrutiny, want of evidence or material to reach such a conclusion, we may add that want of any material is almost equivalent to the next situation that form the available materials. No reasonable man would reach such a conclusion. While evaluating the materials, the authority should not altogether ignore the reputation in which the officer was held till recently. The maxim, nemo firo repente turpissimus, no one becomes dishonest all of a sudden, is not unexceptional, but still it is a salutary guideline to judge human conduct, particularly in the field of administrative law. The authorities should not keep their eyes totally closed towards the overall estimation in which the delinquent officer was held in the recent past by those who were supervising him earlier. To dunk an officer into the puddle of doubtful integrity, it is not enough that the doubt fringes was a mere hunch. So his reporting officer, accepting officer, all have been grading, Lord. Even the CMD has approved his grading of outstanding in 22. But in 23, Milord, on base of recommendation, he takes a different view. Next one. Well, next is K. Kandaswamy. Just I'll delete. Citation 95 6 SSC 162. 6 SSC 162. Well, para 9 Malad. While exercising power under Rule 56J, it is equivalent of the fundamental rule. The appropriate authority has to weigh several circumstances in arriving at the conclusion that employee requires to be compulsory retired in public interest. The government is given power to energize its machinery by weeding out deadwood, inefficient, corrupt, and people of doubtful integrity by compulsory retiring them from service. When the appropriate authority forms bona fide opinion that compulsory retirement of the government employee is in the public interest, court would not interfere with the order. So, Milord, if they come to that conclusion, Milord, it is not interfere. But if it is otherwise, Milord, your lordships would interfere. Milord. But I have also provided your lordships A recent judgment from Delhi High Court, my lord, dated 5th May 2026, in the case of Prashant Kumar Satapathy.
Para.
My lord, identical facts, my lord, he was also a victim of the exercise carried out by them, my lord. As many as 200 officers have been compulsorily retired by FCI.
Okay, which is the relevant para?
My lord will similar identical facts, my lord will take note of para 9, 8 and 9, my lord, for contention of my lord FCI is para 11, 12, my lord. Sorry, para 12 is the contention of respondents FCI. Similar to my lord integrity and all, my lord. Para 15 points out, my lord, that there was penalty that has been imposed upon the petitioner in 2012. And relying on all the judgment, my lord, what are the parameters and governing principles? The points of determination has been discussed at para 16, my lord. And the High Court has dealt with the parameters from para 17 to 21, my lord. From 22 onwards, my lord, the High Court has dealt with each of the issues. Each on, my lord, finding, my lord. From para 22 onwards, my lord. If your lordship permit me to read from 22 onwards, my lord. The record unmistakably shows that the petitioner had already undergone review in 2017 and then was retained in service. The fact assumes significance because clause 7 of the circular, while permitting a further review, contemplates that such exercise be undertaken on account of changed circumstances in public interest. The clause further expects the appropriate authority to demonstrate visible meticulousness, particularly since government servant had earlier been found effective for retention in service. The respondent seeks to justify the second review by referring to the minutes dated 14th January 23 and the backdrop of CBI trap cases involving some officers of the corporation in Punjab. However, the petitioner is not shown to have any connection whatsoever with the said episode. The institutional desire to conduct a cleansing review may perhaps explain why reviews are initiated, but it cannot without more supply the changed circumstances personal to the petitioner so as to justify reversal of an earlier decision of retention in this case. Clause 7 is concerned not with administrative atmosphere in the abstract, but with the expediency of reviewing such case again on account of just such.
Mr. Dubey, you're reading from where?
My lord, I am reviewing para 22.
22.
22, 23, my lord, because
And where do you get clause 7?
clause 7 is, my lord,
Come to para 20.
yes.
Clause 7 permits second review.
Yes, your lordship, recollect.
Second review.
50 years is the first review. After 55 is the second review. Once you have.
That is the second review.
Yes. My lord, kindly come to clause para 25, my lord. It speaks of integrity, my lord. The respondent's case on integrity rests substantially on 4 features. 2 disciplinary proceedings initiated in 2012 and culminating in minor penalties, 1 upper grading of good in 2009, And the fact that for several years, the integrity column recorded nothing adverse reported notice instead of beyond doubt. But little similar to our case, and certain inputs gathered from superior officer and the personal file. But this is not there in my case. The first three of these views in context do not rationally sustain the conclusion reached. The two disciplinary proceedings are of the year 2012 and thus dated. They were undeniably within respondents' knowledge when the petitioner was first reviewed and retained in 17, and equally within their knowledge when he was subsequently promoted to the post of general manager in 2019. Like in our case, we were promoted in 21. While the law does permit the authority to look at the whole record, it does not permit the revival of stale blemishes in disregard of subsequent institutional endorsement by way of retention and promotion, especially where no comparable adverse material from the later period is shown. The 2009 APAR grading of good is even more remote to place determinative emphasis in 2023 upon a single below bench entry from nearly a decade and a half earlier, while discount a line of later very good and outstanding assessment is to invert the very principle embodied in the DOPT-OM and the decisions of the Supreme Court that due weight must be accorded to the later record. The jurisprudence does not permit isolated adverse entries from the distance past to be given undue weight in disregard of the subsequent service record. Equally untenable is the treatment of the integrity assessment, nothing adverse reported notice, as suggestive of doubtful integrity. The material before the court shows that for the years 2017 to 21, the petitioner's integrity was so recorded, and for 22, it was expressly recorded as beyond doubt. In ordinary service parlance, nothing adverse reported is a neutral certificate, not a disguised censor. To construe the absence of the expression beyond doubt as evidence of doubtful integrity would be to read suspicion into what is, by definition, neutral. Such an approach cannot be sustained. The respondents do rely on the general reputation inputs and certain observations in the review committee material, suggesting that the petitioner was not satisfactory in work and conduct. But there is no observation as such, so far as I am concerned. Still, what the apex court says, conduct and reputation in an appropriate case form part of the material as recognized in S. Ramachandra Raju. But such material, if it is to outweigh formal service record, must have some convincing nexus with contemporaneous facts. In the present case, the broad disparaging observation attributed to the committee stand in clear tension with the petitioner's APAR record for the same period, which reflects detailed appreciation of his performance, leadership, administrative capacity, and effectiveness. Where annual assessments consistently rate an officer of very good or outstanding and record specific recommendation of his work, a subsequent assertion that he hardly took interest in assigned duties cannot be accepted as a face value in the absence of any concrete and proximate material. No such material is shown. Let I have a better case than this because I don't have this. If ineffectiveness of the 5 years, the finding of the ineffectiveness against the petitioner is equally unsupported. Clause 10 Roman 4 of the circular explicitly states that a corporation employee should ordinarily not be retired on the ground of ineffectiveness if his service during the preceding 5 years or his service in the highest post to which he was promoted during that period has been found satisfactory. Mine is outstanding, Lord. The petitioner was promoted to the post of general manager in 2019. Thereafter, his APARs for the relevant period contain gradings very good and outstanding, accompanied by strongly positive remarks concerning performance and leadership. On the respondent's own showing, therefore, the petitioner could not ordinarily have been retired on the ground of ineffectiveness. The circular does preserve an exception where the case is of one doubtful integrity. Both has to be read together, my lord. If my performance is exceptional, but if I have a doubtful integrity, yes, they can do it. But this is not in my case. But as already noticed, the foundation for invoking that exception in the present matter is unconvincing. It follows that the safeguard embodied in clause 10(4) was not given due effect. The respondent attempt to escape the consequences by asserting that the petitioner promotion was based on seniority, not merit, like in my case, thereby permitting previous APAR entries to be looked at. The petitioner, however, points out that the post of general manager is a selection post and under the regulations, promotion to such post is on merit with seniority, operating only where merit is approximately equal. The DPC minutes show that promotion is based on an assessment of merit against a prescribed benchmark of very good with reference to the APARs of the preceding 5 years and not on a seniority alone. In my case also, seniority cum fitness, my lords. It's not seniority alone. So when its criteria is seniority cum fitness, my lord, while considering fitness, this all aspect has been gone into by the committee. Even assuming for arguments that earlier entries could be taken into account that merely enlarge the field of consideration, it does not permit the authority to disregard the significance of the petitioner's later record, nor does it dilute the import of clause 10 Roman 4, which accords due weight to satisfactory service in the higher post while considering retirement of the ground of ineffective case. Appointing authority and application of mind. The petitioner also questioned whether the requirement of approval of the appointing authority under clause was met. Since the impugn order is itself issued under the signature of the managing director, who is asserted by the respondents to be the appointing authority for category 1 officer, the argument of total absence of approval may not be carried to its full effect. Yet it does not conclude the matter because clause 12 is not concerned with signature and all. It contemplates real consideration and approval of the recommendation of the review committee. When the order is examined in the backdrop of the material now disclosed, what is striking is not the lack of form, but the lack of demonstrated application of mind to the central exculpatory features of the petitioner's case. Earlier retention in 2017, promotion is 2019, apart in later years, and the latest integrity endorsement of beyond doubt. These aspects lie at the heart of the inquiry mandated by the circular and jurisprudence. Their eclipse from the decisional process renders professed satisfaction legally vulnerable. So is in our case, my lord. Colorable exercise and timing. A finding of malafide is not to be lightly recorded, and the court must be slow to attribute oblique motive to institutional action in the absence of cogent material. The petitioner case, however, is that the impugned action cannot be viewed in isolation, but must be seen in the backdrop of his prolonged and repeated litigation to secure appointment, promotion, and seniority benefits. There is no direct evidence before this court of personal animus in the narrow sense. At the same time, the sequence of events is not without significance. The petitioner had over the years successfully pursued claims relating to appointment, but this is pertaining to his litigations and all regarding his promotion and all. So that is not applicable in our case, Lord. Even if the court were to stop short of definite finding of malice, in fact, the action is plainly vitiated as a colorable exercise of power in law. Lord, I don't go to the extent of malice, my lord. If it is colorable exercise of power, my lord, which is in the present case, then definitely an intervention is required. If power intended to weed out deadwood or officers of genuinely doubtful integrity cannot be sustained when deployed against an officer whose recent service record is demonstrably strong and when the justification rests essential on stale material repurposed at a moment of immediate administrative inconvenience. So is my case, my lord. On an overall prospectus, this court is satisfied that the impugn order dated so and the orders of rejecting prisoner cannot be sustained. The respondents were entitled to review the petitioner's case, but that power had to be exercised consistently with the governing circular and the DOPTOM and the principles laid down by the Supreme Court. The decision-making process in the present case falls short on each of the critical axes. The second review does not disclose the changed circumstances and visible meticulousness required by clause 7, the material relied upon does not reasonably justify an opinion of doubtful integrity. The safeguard against retirement on the ground of effectiveness contained in clause 1 was ignored in substance, and the action bears the imprint of arbitrariness and collateral purpose. The respondents repeatedly emphasized that compulsory is not a punishment. That proposition is unexceptionable. Yet precisely because the order is said to be non-punitive, it must remain anchored to the doctrine of public interest and to a fair appraisal of the service record as a whole, particularly the later years. This is plainly absent. So therefore, my lord, the writ petition was allowed and the impugn order was quashed, and the petitioner was directed to be treated as having continued service for all purpose from the date of impugn order till date of retirement. But we are also seeking similar relief, my lord. I reserve my right to reply, my lord.
Yes.
So far as my lord, the record is concerned of the petitioner, which has been quoted at page 61, paragraph 18, my lord, of my affidavit in office.
Paragraph 16.
Paragraph 18, my lord.
18.
Running page 16.
Yes.
Para 18. In this connection, I say that the vigilance and administrative profile of the petitioner reflects the following position. Number one, the petitioner was charge sheeted under regulation 58 of the staff regulation, my lord. My lord, the regulation 58 is a major penalty, my lord. And then number two is under clause regulation 6, that is for minor penalty. Again, and 3, that is regulation 58. So 2 major penalty disciplinary action was taken and 1 minor penalty. And that clause 58, regulation 58 say that the imputation of misconduct and misbehavior, my lord. It is not that the petitioner was charge sheeted for a simple. Then again, my lord, at next page,
No, consideration was done under regulation 12.
58, my lord, regulation 58 of the staff regulation.
Regulation 58.
58.
Do we have the regulation? This was in the year 2012.
Yes, my lord, this was in the year 2012. Another number 3 was in the year 2018.
No, regulation 12, what does it provide? 58, no, sorry.
Regulation 58.
58. Procedure for
That
imposing
is
major
penalty.
major penalty. So reduction to time scale of pay
He
by
was
2 stages.
same time scale of pay by 2 stages for a period of
This
3
is a
years.
major penalty.
Major penalty.
Where is it defined? Major penalty?
And that in the top regulation 58 is mentioned for major penalties.
No, this is the procedure.
Yes, my lord.
But where's the penalty itself?
Punishment is, my lord, I think it had to be regulation 60.
62. No,
I'm putting that.
don't you want this back? You talk about regulation 58, then regulation 60.
60. 60 is, my lord, with regard to the minor penalty. Procedure for imposing minor penalty, 60.
For that, you've given him reduction time scale of pay by 2 stages, withholdment of 1 increment under regulation 50. This is in the year 2016. When was the first review?
Well, he is not challenged that.
No, when was the first review?
Review, my lord, when the petitioner's case was considered, my lord.
At the age of 50 years.
55, my lord, because he has crossed the age 55, my lord.
No, there are 2 reviews, correct?
2 reviews.
When are they? At the age of 50?
At the age of 50 and
At the age of 55.
55.
So what was the review at the age of 50?
That is not.
What was the outcome?
That is not with me, my lord, because he was promoted, my lord. He was promoted from AGM to DGM, my lord.
When?
Petitioner, my lord.
2020, 21.
21, my lord. That is after the crossing of the age 50, my lord.
After crossing of age 50.
Age 50.
So when did he cross age 50?
Cross the age 50, my lord.
He has another 2 years to go now.
15, my lord.
15.
15.
2015.
2000.
2015. 50 years.
Yes.
Hmm.
But if at all they wanted to exclude him, they could have done at that point of time.
Hmm. So we are at the second review now, isn't it?
Second.
After second review, this decision was taken to retire him compulsorily
Yeah, yes,
in the year 2023.
2023.
Promotion happened in 2021.
21.
There was no problem in the first review
Then we have,
because they promoted him.
since there,
So now you're going back in time to 2014 and
I know.
2016 to demonstrate that he's not suitable. But yet you promote him.
Circular say that we can take the entire record in consideration.
Okay.
So far as the APR of the.
Then what
current year-
about the promotion part?
And that is to be looked into, my lord.
You have balanced the promotion and the penalty.
Well, that promotion will not entitle him to that. He should be considered permanently, my lord. Since the circular says that his entire career has to be seen, my lord.
And how have you construed adverse? Not what was that? Regarding the remarks on the integrity.
Yes,
Nothing adverse.
I'm coming to that, my lord. Page 95, my lord.
Anyway, you have taken with page 61, correct?
Yes, page 61.
Ah.
That the record, my lord. I'm having with the record also. my
Yes. You submit. I'll not interrupt you.
lord. The number 1 says that the petitioner was charge cited under regulation 58 of the staff regulation, right? Memo number so and so dated 28/8/2012, issued by the managing director of the FCI, and he was imposed the penalty of reduction in time scale of pay by 2 stages for a period of 3 years and shall not earn increment during the period of such reduction. The penalty shall have the effect of postponing further increment of pay by order dated 11/3/2040. Then number 2, the petitioner was charge cited under regulation 60 of the staff regulation by memo dated 21/3/2016 issued by the managing director of the FCI, and he was imposed the penalty of withholding of 1 increment for a period of 1 year without cumulative effect by order dated 26/7/2016. Then number 3, petitioner was charge cited under regulation 58 of the staff regulation by memo dated so and so dated 27/6/2018 issued by the managing director of the FCI, and he was imposed the penalty of stoppage of 1 increment for a period of 1 year without cumulative effect by order of event number dated 5/12/2019. So, my lord, in the year 2014, he was penalized, my lord, for 2 years, then again 2016 for 1 year, and then again 2018 for another 1 year without cumulative effect. Then other factor which has been taken into consideration, that is 4, Roman 4, the APR grading of the petitioner also reflects that he was graded as fair during the year 2013. And while working with the other 7 different controlling officers, he was barely graded at the minimum benchmark rating to keep his promotional avenue open. 5, his integrity during the year 2012 was not recorded by his controlling officer and also not clearly certified as beyond doubt by his 7 controlling officers. Rather, it stated as nothing adverse came to notice, which caused serious doubt of his fitness to be considered for continuance in service. Number 6, the committee also took inputs from the personal file, field officers on general reputation of the officer, and the same was not found satisfactory as far as his performance and integrity is concerned. So, my lord, that we can, we have noted down this, my lord, this 6 point observations as reflected in the record of the case, my lord, while the representing committee has considered the petitioner's case, my lord. Then, my lord, again coming to page 95. Page 95, annexure D, my lord. APR grading, my lord. I want to point out the number 2, 13, 14, and 16, my lord. 2, the integrity party says there's sound, nothing adverse observed. Then again, number 3, nothing adverse reported. It doesn't say sound or trustworthy or beyond doubt, my lord. Then 12, the APR grading is fair. One part of it was fair. Then again 13, no record available. Number 14, no reports of any adverse remarks came to my knowledge during the period under the review. So no sound, no trustworthy, no beyond doubt. Then again 16, so far no any adverse remarks came to my knowledge. Then again next page at 19, nothing adverse remarks came to my knowledge so far. So my lord, this starts from 7/7/2021, my lord. Why 2022 and 2023 is not available? Because my lord, the APR has to be an officer has to fill up that APR, my lord, and it has to be forwarded to his next officer, my lord, so that the necessary entry will be made. But so far as the rating that APR of petitioners from 2022 onwards, it was not there because the petitioner has not filled it up, my lord. Want to place, my lord, this annual performance appraisal report of the petitioner, my lord.
Which year?
My lord, from 1/4/2022 to 29/6/2022, and then again 1/7/2022 to 31/3/2023. I think the first page is of 1/4/2022 to 31/3/2023, my lord.
Mhm. Then the other one?
Then the other one will be 1/7/2022 to 31/3/2023.
Where is that? You should have paginated this.
My lord, and next day I will paginate it and again I will place it, my lord. So an officer has to fill it up this APAR, and then it has to be forwarded to his next officer, my lord. So for the period from 2022 to 2023, he has not filled it up, and that's why it was forced forward to the upper level, and that's why there is no marking, my lord, by the reporting author or the reviewing authority.
What is the year exactly?
Year from, my lord, 1/4/2022. First period 1/4/2022 to 29/6/2022. And then again 1/7/2022 to 31/3/2023. He was compulsorily retired on May 2023, my lord. So these are the facts available, my lord, which your lordship will consider.
So the self-appraisal has not been filled up?
No, not been filled up by the petitioner.
Okay.
There was no self-appraisal, so no assessment by the reporting officer or by the reviewing officer, my lord.
So these are all blank, is it?
These are all blank.
And now if it's blank, then what kind of report is prepared?
Nothing, my lord, that's why.
There's nothing.
Yes, my lord. Only the signature will be there, my lord, signature of accepting officer Subodh Kumar Singh, chairman,
Santosh Kumar Thakur,
CMD.
reporting officer Rajesh Chaudhary, Junior. What is this page? Wherein you have given some names.
These are the, my lord,
Reporting,
officers, the
reviewing,
reporting
and
officer and the reviewing officer, my lord.
Ah.
That CMD and the executive director, my lord.
Name, designation, and period of the reporting, reviewing, accepting author under whom the SSC worked. So these are just the names. There was no remark because there was no self-appraisal. Reporting. No reporting. Before reporting starts, the employee has to
Yes, my lord. Self-appraisal here.
Self-appraisal has to be filled up.
And forwarded to its next officer. The next officer was the general manager, my lord. So it
Who is the
was-
reporting officer?
Yes, my lord. So it was forced forward to the upper level, my lord.
And from there, it goes to the executive director
Yes, my lord. CMD, my lord.
for review.
For
Then to the CMD.
Yes.
CMD is the accepting authority. So this happened for this particular period,
Yes, my lord. On the from 1/4/2022, my lord.
1/4/22 to 31/3/2023.
31/3/2023.
This is for one calendar year or financial year? One financial year.
It's more than one financial year.
It is one
Yes, my lord, one
financial.
financial year.
Calendar year means January to December. Financial year means from April.
1 April.
1st April to 31st March of next year.
Yes.
So it was for this. And where has it been reflected here in this chart?
No, it has not been reflected because no self-appraisal was done by the petitioner. At top of the page 95. It's serial number 17721.
It starts from 21 only.
Yes, ma'am.
But this 7721 to 31/12/2021 is also for 3 months.
And then again at page serial number 2, 6 months.
6 months, 6, 7, 8 months. 9 months. So isn't it to be
11 months, I think so.
11 months?
Number 1 is 5 years, right?
1, 2, 3, 4, 5, 6. 8, 5, 10. Eleven months, correct. So it's basically taken as a one financial year. 7, 7. 1, 1. But how do you explain this period? It doesn't go like financial year.
Yes, ma'am.
You're starting from January.
One calendar year actually.
Calendar year.
Yes. In earlier occasions also, but in a calendar year, if blood lordship is seen in the first entry, it's almost for 6 months, 7 days. At serial number 2.
The system is that you assess as per the calendar year.
Yes. Calendar year.
Not financial
No,
year.
not financial year.
But then this format which you have produced reflects the calendar year and reflects the financial year.
Financial year.
You have given me this basically to demonstrate that there was nothing which had been submitted by the petitioner.
Yes, ma'am.
So it remained blank.
Yes.
For this period. But how do you explain the financial year thing?
I will next day I will take instructions.
Annexure D is as per calendar year. This is as per financial year.
So, my lord, these are the facts available. My lord, the law point, my lord, my senior Mr. K. Chaudhary will submit it on 16th of hearing.
When will you appear?
Thursday, my lord.
Don't make it a very long date, we'll forget.
Day after tomorrow, if your lordship.
I have another part matter before your lordship. So that's a huge matter.
Huge matter? What is that huge matter?
That was, my lord, pertaining to forward.
Transfer?
That was also pertaining to service matter, my lord.
FCI only.
FCI.
You were for the FCI only.
But I'm little relieved, my lord. My friend says that matter is used, mine is not. So
Yours is a simple matter.
Yes, yes. On 27th, man.
So that's why senior counsel will come now.
7.
So it's not a simple matter. He has laid down the facts and the senior counsel will argue the law points. What did he say?
27, my lord.
No, 27 will be too late. You see, let us have before that.
We'll try on 20th,
Huh?
or on 24th. my
We'll have it on Tuesday on a hearing date. Because other days there are a lot of motions. We can't finish motion from morning to evening. We have motion only.
Better my depends on our hearing date.
That's why.
No, let it be on 27. 25, I have great difficulty. Or we will try on 28.
No. 25 senior will come and argue. You may have difficulty. Mr. Ken Chaudhary is arguing, isn't it?
7, only 15 minutes.
Or have it day after tomorrow. What is
We'll
that?
try.
Let us try day after tomorrow.
Tomorrow.
Today is 18.
Day after tomorrow.
No. Please write. By filing this writ petition, the petitioner has challenged the order dated 8/5/2023, bracket annexure 1, by which he has been compulsorily retired from service. And also the order dated 12/7/2023, bracket annexure 5, by which his representation was rejected. By the appellate authority. So by the time of being compulsorily retired, the petitioner was working as Deputy General Manager within bracket General, and was due to retire in the month of January 2025. Had he been allowed to complete his entire tenure of service, the retirement age being age of 60 years. Mr. R. Dubey, learned counsel for the petitioner, submits that the impugn order of compulsory retirement is not sustainable in law. In view of the fact that the respondent authorities have failed to take into account all relevant aspects of the matter. Particularly the promotion which he had earned in the year 2021, before taking a decision to retire him compulsorily. Stop. He also submits that the representation of the petitioner was not given due consideration it deserves, and that rejection, and that the order of rejection does not reveal any such consideration that the respondent authority concerned ought to have done. To support his submission, the learned counsel has relied upon few authorities which has been taken note of. Stop. Mr. Your good name, please. BK Singh. Mr. BK Singh, learned standing counsel, FCI. On the other hand, by referring to the affidavit of position, has submitted that due consideration was taken into due consideration was made prior to taking the decision to retire the petitioner compulsorily. Top, he also submits that the petitioner had failed to initiate his APAR for the years 2020, 2022 and 2023.
I know.
And for which reason there was no APR for these 2 years. Stop. He also submits that he's being led by Mr. KN Chaudhary in the matter, and therefore prays that the matter will be taken up for further hearing. On a convenient date. Next para, as agreed to, place the matter on 20. Huh? Oh, 20, of course, 20. I heard 8. That's good. As part heart. Okay.
Apply due to risk.
For hearing item 54.
May it please your lordship. I'm appearing for the appellant insurance company. The matter may be passed over for the day. As my senior counsel is alleging court number 5.
Insurance company.
Yes, Your
Item 24, is it?
Yes, Your
You're for the claimant?
For the claimant.
Okay. What benefit have you got?
I filed a cross objection for enhancement. I filed a.
What benefit have you got so far? Any payment?
No, 50% you know, little paid.
Or 50% you have taken?
Yes.
Okay. Is it a standard procedure that one gets 50% before hearing?
Well, lordship, at the time of admission and taking the stay.
Okay, that was a condition.
Yes, Lord.
Condition for stay was deposit 50%.
Yes, Lord.
And you submitted application for withdrawal.
Yes,
It
Lord.
was allowed. How much was the amount they awarded?
Amount was 15 plus, lordship.
15 plus
Yes, sir.
lakhs.
And I've taken 799.
Okay. And you have filed cross objection, cross appeal.
For enhancement, lordship.
Cross objection or cross appeal? Cross objection.
Cross objection, lordship.
For enhancement.
Yes, lordship.
Okay.
And there is actually nothing in their appeal, lordship. And the thing is this, lordship, my deceased was the advocate's clerk. And he was getting monthly salary 50,000 lordship.
How did you prove that?
The author of the advocate has proved that.
Okay. The learned counsel had appeared to depose.
Yes, lordship.
Okay.
And they deposited and everything in the.
50,000. 50,000. How much did the tribunal give?
Tribunal give 9,000 lords.
9,000 per month only.
And the age factor is also there, lordship, that age was 40 years, 1 month. So it should be taken as 40. And in PM it is 42 lordship. But he was a bachelor degree holder. So age of the 40 plus 1 month.
PM means?
Postmortem.
Acha.
Postmortem, there is apparent lordship. Ossification test is also.
PME. PME.
Yes. But in that degree certificate, lordship, 40 years. So that is another ground for enhancement.
So the multiplier factor will increase.
Yes, sir.
Hmm. Who's the counsel for the appellant?
M. Chaudhary. M. Chaudhary.
MSM Chaudhary. She's on legs.
Yes, Your Lordship.
You want Passover or Passover for the day?
Passover for today.
For the day. 2015 matter. We'll fix a date. Let's have a date. Okay. The conducting counsel, MSM Chaudhary, is said to be on legs in a different court, and therefore a prayer for adjournment has been sought for on her behalf. Mr. A.R. Agarwala, learned counsel, appears for the respondent claimant and submits that the claimant has also filed cross objection for enhancement of the award. He also submits that 50% of the awarded amount has been deposited and withdrawn by the claimant. Next para, considering the fact that the appeal is of the year 2015, let the matter be listed on 10 September 2026 for hearing. Okay.
25.
Oh, sorry. None appears for the appellant when the matter is called. Stop. This is an insurance appeal against the award of the tribunal, Motor Accident Claims Tribunal, wherein an amount of rupees 14,30. No, please rewrite that. Rupees 14,31, 000 has been awarded to the claimant with interest at the rate of 6% per annum from the date of filing the claim till final payment. Next para, the matter was last listed on 4/5/2019 and was directed to be placed in the next Lok Adalat. Stop. It appears that the matter has not been placed before the Lok Adalat, as there is no record in the order sheet. Stop. Since the matter is of the year 2016, registry to list the matter for hearing on, give a date, 15/9/2026.
27.
May it please your lordship. Before lordship, my learned senior start. My learned senior advocate H.K. Das is on legs at court number 10. The matter is going on. So that I was just, yeah. So my lord may take it after some time.
This is item 27, is it? Yes, what do you say?
Yes.
Time being,
In-
Paso.
In fact, we have got here this stay vacation petition.
Hmm.
So that was not taken up and then matter ultimately it was fixed for hearing because
see.
there's some urgency on your behalf. Because promotion is held up, my lord, with stay order, my lord.
Hmm.
So shall I
You are appearing for the
respond to 5 and 4?
private
Yes.
respondent.
Yes,
Okay. This regarding promotion matter.
promotional matter, seniority promotion, seniority was given
Hmm.
and my juniors above my, I have come, initially I was placed before the junior, below the junior. Although I was senior, that was rectified, my lord.
Seniority in the rank of inspector, arm branch.
Yes, madam.
That is the dispute.
The contention of my learned senior here, that the stay vacating application. What had happened, my lord, after I got my stay, there was a provisional gradation list that had been filed, that they have brought in. And I had challenged that provisional gradation list by IA number 189 of 2024.
Hmm.
The Honorable Court disposed that IA basis on the order of 28 to 2024,
Saying what?
saying that Mr. K. Kumar, learned advocate, additional advocate general on instruction submits that the provision gradation list would not be finalized till disposal of the main writ petition number 1525 of 2022. Recording the submission made by the learned additional advocate general Assam, this interlocutory application is accordingly disposed of. And
That was
thereafter they have filed the IA for stay vacating in 20.
Of vacating that order.
Yes.
Okay.
No, not this order, vacating my interim order.
What was the interim order?
In that no course of action would be superseding the petitioners. The facts of the case is such, my lord. I can place the facts of the case in lordship. Please.
I think, my lord, since he's the petitioner, let him place the fact, then I'll place. Let him start. It will be easier, I think.
Who's the arguing counsel?
Yeah, I'm like, I was arguing, but now they have engaged a senior now, Mr. H.
Who?
K. Das.
H.
H.
K.
K.
Das.
Das. So that is why I still hold the brief, but because the client has, because they have engaged a senior advocate on last occasion. So to balance the weight machine, so they have also, the petitioner also have engaged a senior advocate.
Okay. What about the state?
State is
They're watching from behind.
Yes. No, state has filed the affidavit also.
The issue is actually very small.
In fact, by the Assam police, in fact, in the last order, the lordship, the advocate general was asked to bring the police manual, like which rule will follow. Because in their affidavit, they have stated that they would follow the financial and audit rules. But as per the police manual, part 3 and Assam Police Act section 115, the respondent here in the private respondent does not even qualify for the service. For being promoted.
My lord.
Yes, my lord, I can show that. If
Now,
Lord-
let it.
yes, if that is what my lord,
See, problem is that once we start and we can't complete again, part hard, it was a bit difficult. It was just the case before this also was part hard.
Previous matter I have seen.
So one tends to forget, what was heard that day. So let us wait for some time.
Yes,
and
madam.
if it's not
after
coming, then
Madam,
we'll fix a date.
yes. My lord, in fact, I'm
We'll fix a short date.
extreming the code 10 where he's still on legs, my lord. That is why I'm on a submission. Much of it.
Timely.
28.
Oh, this was your case,
28, yeah.
which was almost adjourned.
28, this is the.
28.
Yes, sir. Your lordship. In this matter, your lordship, the petitioner before your lordship had already retired from service, your lordship.
Retired.
Yeah, they are actually, they have been engaged in work master workers from the period 1983 to 1989, your lordship.
Yes.
I'm appearing on behalf of Mr. P. Nayak. A similar matter has been taken up.
No, that is not similar. That's not similar.
Case
Mine,
on legs.
mine matter is totally different, your lordship. They
Pertains
are relying on Upendra. Upendra has no concern with me on my case, your lordship. That is Upendra is pension. My case is, I am claiming regulation also in service also because there are junior people who have been regularized, your lordship. And the government documents are there in support of my case. That matter is no connected here.
Okay. Anyway, but one has to appear. You see,
Yes, yes.
somebody has to appear for the.
Lordship, he is in the midst of a hearing matter.
Let it be day after tomorrow, Your Lordship.
I don't know.
I have no problem with that. She's in difficulty, I have no problem.
Third,
Your Lordship.
we'll have it on third of,
I won't be there, Your Lordship.
huh?
I won't be there. I just came for this matter.
Oh, you came for this only.
It's a short matter. It don't take much time. After tomorrow, I'll finish.
No, provided the parties are here and time permits, we can definitely.
I'll be.
Then you give me a date when you will be here. Give us a date when you'll be here.
I have to finish it up because they have all retired, Your Lordship.
Hmm?
They have all retired, and some of them have expired also. That's the problem. I want to finish up because these are poor people, Your Lordship. I don't want to drag on them.
That's a problem, you see.
Because they are coming again expensive. I don't want them to bear the expenses also. You know, that's the problem. They're very poor. We have retired as small people also. Work as employee, how much they get because that's it.
Problem is that we can't take up today, na? Because the other side is not here.
Well, I'll try it. Let me be after that.
Day after tomorrow, we have fixed some matters also, part-hand matters.
This matter won't take much time. Your half an hour, 45 minutes.
Okay.
They can't afford every time. Expenses are expensive. They're all master workers. And some of them are represented by the wives also. They have expired. 3 of them expired already.
No, but you have other cases also, Mr.
Yes, I know that, but I'm pointing a difficulty from my side, Your Lordship.
You have other cases also.
I know.
So that's why not you will come. You will come on another date for this case as well as the other cases. Give us a convenient date. Thursday will not be possible, you see. Not practicable. Mr. P. Chaudhary, learned counsel for the petitioner, submits that the instant case is not similar to the other case referred to by the learned counsels for the state respondents. And therefore, the same can be taken up without waiting for the outcome of those cases. But however, the conducting counsel for the state, that is Mr. P. Nayak, is said to be on legs in a different court. Accordingly, let the matter be listed on so and so. Give a date.
22nd of September.
Fine. 22nd of September for hearing.
Oh, please.
Deeply.
Wait, please, Your Lordship.
This for the other side.
Mr. B. Chakravarti.
Chakravarti, sir, he's in another court, Lordship.
B. Chakravarti. Huh?
If I start, he'll come next.
Is he coming or not? Thing is that we don't want to leave it loose ends. Again, part hard and all that.
Matter is relating to compulsory retirement
Hmm.
and very much similar to item number 33.
Hmm.
So I won't take that much of.
From which post?
He was a superintending engineer.
Government of Assam.
No, he was a superintending engineer in.
Gref. BRO.
Organization.
BRO.
BRO. Otherwise, the file looks bulky, but most of the things are actually repeated. So I'll just take your lordship to certain page only. And in fact, the mala-fide intent of the respondents would come to the fore. Of course, the mala-fide intent of the respondents will come to the fore. So I have actually challenged this, challenged the whole disciplinary process as well as the penalty, based on the grounds which I have actually enumerated in the synopsis itself.
Retirement was in 23.
I'm sorry, Your Lordship.
Retirement was in 2023.
Yes, just 3 months prior to his date of retirement, he was retired, compulsory retired.
So, what benefits are you losing?
Basically, promotion, because I was supposed to get promotion, but just before the DPC was set, they first suspended me, and then my juniors got promoted to the next rank of chief engineer, and ultimately ADG, that is Additional Director General Border Roads, but I could not because I was this disciplinary proceedings were going on, and just prior to 3 months of retirement, I was compulsory retired. So
The compulsory retirement was an outcome of the proceeding.
yes,
In the form of a penalty.
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 But the other matter was not a penalty.
Other factor was not penalty, but one judgment.
Under the BRO, it's penalty.
Penalty under CCA rules.
CCA.
So under the CCA rules, a major penalty of compulsory retirement was in. So based on that only, I could not get the promotion and everything. So that's why if this particular penalty goes, because there are many grounds on which I challenged this particular whole disciplinary proceedings as well as the penalty. So more.
So what is the relief that you're seeking now?
Basically setting aside the penalty and granting me the promotion, the opening of the seal cover.
Oh, there was a seal cover procedure.
Yes, seal cover procedure.
So that compulsory retirement has been given to you as in the form of a penalty.
Penalty.
If that goes away, then the seal cover will open.
It will be open.
And you can get the notional benefit.
Yes. Because otherwise I'll be, anyways, I would have retired by now. But just 3-4 months prior to my retirement, this order was passed hastily. Because there were many shortcomings in this whole inquiry process. And in fact, the inquiry report also came in my favor. The charges were not proved. But even after that, they issued a disagreement note. And the disagreement note itself, they stated certain facts and said that the charges are proved. That's why we intend to impose a penalty upon you. And then I represented, and then even then also they did not pay heed to that representation and ultimately imposed the penalty.
Seal cover procedure.
Yes.
Was for promotion to which post?
Chief engineer.
Chief engineer.
Yes.
He retired as superintending engineer. So Chakravarti, you ready?
It's an accommodation, sir.
Huh?
Because not prepared for relief down. So it's some accommodation.
Okay. Time is also not very.
It will need some deliberation also.
Whether records will be required.
Records may be necessary.
Not
necessary.
Because, I have not challenged anything pertaining to the records. Actually, the case of the petitioner is such that he went on deputation to NHIDCL. Therein, one particular contractor was selected on the basis of certain documents which the contractor himself has submitted. And that selection procedure of the contractor.
The allegation is that he provided those documents.
No.
That is the.
No, that is not the allegation. The memorandum of charges says something different. So the contractor, his documents were verified by an external agency. And NHIDCL, they have a definite specific set of pattern as to how to select a particular contractor through the bidding process. So he was just a member of that particular committee. In fact, the work order, everything, letter of award was awarded by the MD. Now there are innumerable case laws to that effect of the Honorable Supreme Court that other members of the whole tendering committee were not mere ciphers or mere spectators for that matter. And the scrutiny of documents submitted by the contractor as such is not the responsibility of the petitioner because he was just a member of that particular committee. Now, when the contractor's documents were found to be fake and forged, the contract was terminated and his bank guarantee was encashed. And otherwise, there is no loss to the state executive because they got more than actually what the loss was actually happened. Because the contractor's bank guarantee was running to around many crores. And the work that was actually done by the contractor was much less. But then what happened? The contractor, he wanted to claim certain area pay, area dues. And in those dues, in that particular case, where that is a mediation case before Delhi High Court, after a span of 2 years, what had happened, he alleged that there was not naming the petitioner also in his whole plaint. He never named the petitioner. He said that there are certain individuals who helped me procure those documents, not naming anybody. And then he said that I have got phone recordings of those particular individuals. Allegedly, one of them allegedly was the petitioner. But what had actually happened, only the petitioner was singled out after a delay of around 2-3 years. After he was repatriated, the whole contractor was actually cancelled.
Okay, so it'll take some time.
It'll take some time.
We'll have it some other day. And you have completed the NHIDCL also. Do they have any role?
They have
It was on deputation at that
They had the
point of time.
And inquiry was done by whom?
The preliminary done by the NHIDCL because as per the CBC guideline, while you are serving there at that point of time, the preliminary inquiry has to be conducted before issuing the charge memo. The original that
Preliminary
DP was conducted by us.
Preliminary inquiry.
Inquiry and DP was conducted by the
NHIDCL. Because at that relevant point of time, he was on deputation.
The whole matter as such happened in NHIDCL.
Then after the inquiry report is prepared,
Yes.
then what was the procedure?
There is a disagreement note, Lordship.
After the inquiry report was prepared, everything was not, no charges were not proved. And after submission of the charge inquiry report, they issued at the same time a disagreement note saying that
Who?
the disciplinary authority,
Who is that?
that is the Ministry of Defense.
Okay,
Secretary
in the
Minister of
VRO, they disagreed.
Yes. And so Defense Secretary, so they issued a disagreement note saying that we do not agree with the inquiry report. And you were given after submission of the inquiry report, they wanted to better their inquiry report and saying that you were given opportunity to, submit voice sample, which should have been done during the inquiry proceedings actually. But that did not happen. So they wanted to better that inquiry by again instituting a de novo inquiry, but they could not because the petitioner said that no, the inquiry process is over. The report is in my favor. Now you cannot initiate a de novo inquiry till you find a better because the judgment should have effect also. The disciplinary authority cannot better a particular inquiry process.
Then what happened?
So ultimately, they, in the disagreement note, they gave an explanation. So what explanation? So what explanation? And they came to the conclusion that the charges were proved. So now you'll be imposed penalty.
Okay, the inquiry report along with the disagreement note was given to you.
Yes, I represented.
And saying that why you should not be given a thing.
Yes.
Then you represented, but it was not accepted. Then that compulsory retirement. 3 months before the actual retirement.
Yes.
Thereafter, any provision for further appeal?
No.
You can only seek a review.
No. Review because appeal because this order is in the name of the president. He was a superintendent engineer. So the order itself reflects the name of the petitioner, the president. So under section 25 of the CCA rules, any order in the name of the president is not appealable.
Or the governor.
Or the governor, for that matter. So there is no provision of appeal. Now,
review. What about review?
There is no such case of review also. Review can only be done under Rule 29A, revision, not review.
Revision.
Review because I have to have some ground to challenge that. I don't have any ground, a new ground or any new fact. Then only a review would like. Or for that matter, revision under section 29A of the CCA, Rule 29A of the CCA rules. Now, even revision also, same, the whole clause Rule 29A says that you must have something new fact, new evidence, so that the order of penalty can be reviewed. So I don't have anything of that nature. So why should I actually take recourse to Rule 29A for the matter? In fact, they have stated in the affidavit also that I should have gone for revision under 29A. But I would have gone to under 29A had I had any ground.
Okay,
So that is why. I have
all right,
approached your-
so. Parties are represented by the respective councils, Mr. B. Chakravarti, learned counsel for the respondent.
One to four, no.
1 to 4. Place for some time to prepare the matter. In view of above, list this matter.
Your Lordship, can it be earlier? Because August, Your Lordship, if it is possible.
August, I don't think it's possible.
Again, September, Your Lordship, puja holidays would begin from October, that's why.
So take 22nd.
Your Lordship, can it be on last week of August, Your Lordship, 28th of August,
No, no.
27th of August, Your Lordship?
It has to go to September. What is the urgency?
Lordship, otherwise, urgency, of course, he is now
The
complete.
2025 case, there are many cases of 2016, 17.
So,
Okay.
can it be 8th of September, Your Lordship, if it is possible?
Okay, 8th of September.
Highly appreciated.
Yes, Miss. Miss Tinlu. Learned counsel appears on behalf of Mr. R. K. Talukdar. Representing respondent numbers 5 and 6.
P1.
This matter has to be heard finally. I am prepared, I will take only 15 minutes. Your Lordship alone. He was a master worker. He was dismissed from service. The dismissal order was set aside by this court, by judgment. And thereafter, my lord, new process was started, totally in violation of Rule 9 of the disciplinary rules. No prosecution witnesses, no opportunities of cross-examination of any witnesses. I find from the inquiry report, no witnesses have been reduced.
What is this inquiry report?
Inquiry report I have already submitted.
It's in the
itself.
It's in the cost list. It says
Yes,
with
I
with
find
inquiry report.
Surprising, my lord, it is there with me only, page 45. Page 47 is the inquiry report.
Huh?
I'm appearing on behalf of P. Nayak. He's still on legs and coach.
Who?
P. Nayak.
P. Nayak.
He's still on legs.
He appears for which respondent?
Lordship PWD.
PWD.
I can finish my argument, they can come because they can already that is.
No, Mr. Das, not like that. You don't know.
Inquiry report is already there at page 47.
47. Page 47.
Yes,
Reference of additional documents read during the
46 one. Inquiry report.
Then what is this file then?
That I don't know what.
Inquiry.
Yeah. Maybe record man. My lord, in short, your lordship will kindly understand, there is no prosecution witnesses, there is no opportunities of any cross-examination, totally in violation of provision of Rule 9. Their only plea is that he is a contractual employee, he is not entitled to so much of, that has been already clarified by this court while setting aside the earlier order of this.
Oh, this is the same thing.
Same thing, yes.
Same thing. Why they have again sent separately?
No, don't know. Last occasion, they have said we need to inquire.
But unless Mr. Naik is here, then it'll be difficult. Mr. Das.
Your lordship will kindly, because it is fully covered by a judgment of Supreme Court. It says where in the proceedings, there is no prosecution witnesses, where there is no opportunities of cross-examination, any witnesses. It goes. Simple as that. Rule 9 has been totally violated.
Let the other side be there, then we'll hear.
Well, next Tuesday, your lordship will fix it. They have so many advocates, my lord, in panel. Once, my lord, he was dismissed, it was set aside by this court. Then thereafter, my lord, new proceeding has started from page 44.
We'll have a date sometime in September, Mr. Dahab. 15,
Yes, sir.
15 September.
Well, not 15 September. my lord. If it is first week of September, it is only. Otherwise, next Tuesday, my lord, I will not take much time.
No, next Tuesday we have got few Parhat matters, that's why.
Thursday, my lord.
Thursday also same thing.
First week, well, I will not take time, my lord.
Give a date in the second week if possible.
Second week, my lord, I will not be there.
Okay.
7, 8. 8 is a hearing day.
8th?
8, sir.
Okay. Is it so? Mr. Das, 10th? There are a lot of matters on 8th, it seems, that's why. Okay.
My lord, Mr. Naik is not there, your lordship.
Okay, although Mr. B.D. Das, learned senior counsel, is for the petitioner is present. Mr. P. Naik, learned additional AG, appearing for the respondent PWD is said to be engaged
Yes.
in a different court. So accordingly, the matter stands adjourned to be listed on 10th of September 2026. This is for admission or hearing?
Hearing, my lord, it has to be hearing.
For hearing. Yes.
Your lordship, in this case, I was appointed as a.
Wait. Before you start, who's for the other side?
CGSC.
Union of India. What happened today?
All right, your lordship, I fix it. Day after tomorrow.
Day after tomorrow. Oh, he's here. What is this matter? Short matter?
It will take some time.
It'll take some time. Then we have another date. See, time constraint is there. Give a date. 15th of September.
I'm very grateful.
Okay. List for hearing on 15th of September.
1927.
My lord, if possible, can you take another 3rd of next month? Joint, 3rd September.
Okay,
It's better, I think.
as agreed to by the parties, rival parties, list for hearing on 3rd of September.
Yes. The interim may continue.
There's an interim order passed earlier to continue till then.
There's no point also taking now, my lord. Now time is very short.